We will call to order the Board of Election Commissioners for the City of Chicago, constituting ex officio the Electoral Board, to hear and pass upon objections to the nomination papers of candidates for offices to be nominated or elected at the March 17, 2020 general primary elections. Good morning. My name is Maricel Hernandez. Seated to my left is Commissioner Jonathan Swain. The next item on the agenda is the Rule 20 hearings, and we're going to take this a little bit out of order. We will call 20 EBWC-007, Quintella Benson and Ava Thomas versus Anthony A. Beal, Ward Committee Person, 9th Ward, Democratic. If the parties could please state their appearances for the record.
Laura Jackson, J-A-C.
I'm sorry?
Laura Jackson, J-A-C-K-S-A-C-K for the objectors.
Can you pull the microphone a little
Yeah.
closer to both of you? So,
And make sure it's on.
yeah, make sure it's on, the brain's on.
There's a button on the front. There you go.
There you go.
For the candidate, Bert Odelson, O-D-E-L-S-O-N.
And Ross Seckler, S-E-C-L-E-R.
Okay, and this is the candidate's Rule 20 motion.
Yes, Madam Chair.
Okay, well, can you could start.
Thank you. There are two main issues. The candidate, Alderman Beal, as a result of the record exam and the evidence, has been recommended to be off the ballot, being 6 signatures short of the minimum. There are two areas that we bring up in our Rule 20, both very, very serious, I think, and something that requires the attention of the board in order to protect the electoral process itself. The first issue, and Ross is going to give you copies, which we've tendered to council, of the records, to make it easier for you to follow rather than having to go through the entire record. The first issue, which is in Exhibit A, has to do with duplicate signatures.
And here we have to object. It's in Rule 6 clearly that the candidate or any party who does not preserve an objection at the records exam, meaning they do not appeal a ruling at the records exam, cannot present even any evidence or any argument regarding those findings.
We'll take note of that. Thank you. Continue.
Thank you. And we're not presenting any evidence. We're just taking the results of the record exam by your clerks and arguing as to why Alderman Beal and the signatories were deprived of their due process and their right to have their signature counted. Quite
But is that
simply.
true? You're saying they were deprived of due process to have their signature counted?
Yes, and by that I mean someone signed their name and then signed it again somewhere else on the petition, and in a couple instances signed it a third time somewhere deep within the petition, and the record exam clerk ruled all of them as invalid. Whereas the past practice of this board, although you don't have a rule to that effect like the county and the state has, the past practice of this board is to count the first signature and then to sustain the objection as to the second or to the third, so as not to have one person's name counted more than one time. That's been the way it's been here for decades. In this case, the first signature was not counted, the second signature was not counted, and in some cases, the third signature was not counted. So in 5 different instances, the record clerk sustained the objection to duplicate signature on every single signature. So the person who signed it, signed the petition, whose signature was not objected to for any other reason other than it was a duplicate, didn't have his name counted at all. Now, the counsel for the objectors has told you, and it is correct that the watcher did not object to the call of whatever hearing a records clerk was presiding over the record exam. Quite frankly, in this case, it's not a matter of preserving an objection, it's a clerical error, a ministerial act by the records clerk who should have overruled the first objection as to duplicate and sustained the second or the third. So we're not here arguing that all of the signatures should count, or 2 out of 3 should count, but certainly 1 should count. And that our watchers not objecting to the call is a result of a number of problems. 1, and I don't know this, it could have been different records clerks and different days. 2, procedurally and past practice has the board ruling the first signature valid and then the second or third.
I'll take you in a minute. On this particular issue, do you
Yep.
have any other points you wish to raise?
No.
Okay, so I'm going to stop you right there.
Okay.
And you have other arguments.
Just one other for
Okay.
a different set of facts.
Can I just take each
Sure.
issue?
Yes, ma'am.
Okay. Can you respond?
Madam Chair, before we go, I just want to clarify,
Yes,
Mr. Olson, can you repeat what you said again as to why, the last statement you made about different record clerks, I want to make sure I caught that.
Our watcher did not object to the finding of sustaining the objection as to duplicate signature. In other words, didn't
Right.
preserve the objection in any of the cases. So every time the records, your records clerk sustained the objection as to duplicate signature, it went down as a sustaining the duplicate signature. Each of the duplicate signatures were sustained as not valid. So the candidate was not given credit for any
Right,
signature.
but you stated a reason as to why, that's what I wanted to hear.
Speculation, he did say he doesn't know.
I understand that, but I want to hear what he said.
And it is, Mr. Laster's correct, it is speculation.
Mhm.
I don't really know, as I sit here, it could have been different record examiners on different days when they sustained the objection. I just don't know, number one. Number two, ministerially, the board should count one and not count the others when there's a valid objection. And there was a valid objection. So we're not here saying that you should count them all, you should count 2 out of 3, just count 1. Don't deprive that person of their signature.
Okay, Ms. Smith?
And I, again, just emphasize Rule 6, which is the only rule, besides Rule 8, which repeats the same thing, that is bold in the rules that says your watcher must preserve, if your watcher wants to appeal a finding, he must preserve it at the records exam, and if he does not, you will not be allowed to argue or present even any evidence regarding this. And the reasons are obvious. Although counsel's saying it's just a clerical error, I could certainly say every ruling that doesn't go my way at the records exam is a clerical error, and therefore I bring them all to you right now, the board, at the Rule 20. We can't just be having a repeat of the records exam constantly. There were over 1,800 signatures. Not everyone had an objection, of course, but some had multiple objections. We can't just be doing this sort of later. There were pages and pages of duplicates and triplicates. So counsel takes issue with 5 here. But we can't just, and I don't concede even the ones that are in here. Some of their Rule 20 actually were overruled, some didn't even appear in their Rule 8, so I don't even concede this on what's on the page, but I just emphasize again that if you don't appeal it in the records exam, you cannot present any evidence to the contrary. And counsel did bring up one case which actually supports us. I'm not sure why he brought it up, of Lanford, and the hearing officer there just said over and over, no signature where an objection was not preserved at the records exam was considered in the final recommendation. That is a very clear rule. You've got to train your watchers. And no matter what happens at the records exam, if you don't like a ruling, you've got to object.
Mr. Odelson, I just want to be clear. Watcher did not preserve the appeal on these signatures, is that correct?
Yes, ma'am. That's correct.
I just want to make sure that that's clear.
Can I
we-
just briefly respond?
Very
Real
briefly.
briefly, yeah, yes. This procedure is not a "I gotcha." This is a march towards the truth. Is it a good signature? Is it a bad signature? Should it count? Should it not count? This area of duplicates doesn't require any evidence, and that's why we preserve our objections at the record exam to present more evidence, to present affidavits, to present testimony as to whether someone is registered or not registered. Someone is out of the district, is in the district. It's a good signature, it's a bad signature. You see affidavits all the time, you're going to see them again in another minute. This is I gotcha, because the clerk for the candidate did not preserve the error by the records clerk in sustaining all the duplicates. The candidate suffers, the signer suffers, because none of that person's none of the signatures are counted.
Not even one signature was preserved by the watcher for appeal. That's right?
That's correct.
Okay.
That is correct.
You said you have another argument?
Another issue?
Yes.
Okay.
Please go ahead.
Thank you. We handed out a group of exhibits, Exhibit B, and these are, oh, you do it now? I'm sorry. So Ross is giving you Exhibit B. There are,
Second step, right?
this is perhaps even more disturbing. There's no issue here as to preserving the objection. These were all properly preserved. But what you have here is a very interesting phenomenon, even interesting to me. And if you take the first sheet, it's easier for me just to go through it. The first sheet, if you look at the yellow section, on sheet 4, line 7, the objection was invalid signature. The original ruling was sustained. Your handwriting expert overturned it. Okay, let's stop there for a second. So your handwriting expert overturned the clerk. Okay, that's where it should stop, because it's your handwriting expert. However, what happened in this case, objectors, if you turn the sheet, objectors went out and got an affidavit from Ms. Nash, and the affidavit seemingly says that on sheet 4, line 7, it's not her signature. That's what the affidavit says. However, if you turn to the next sheet, it's the petition sheet itself, and if you look at line 7, the signature on line 7 is not close. It's exactly the same as on the affidavit of the person who says that's not my signature, when your handwriting expert says it was her signature. And if you look at the petition itself, you see it is her signature. Now, what's wrong with this story? Your handwriting expert, who looks at the registration card where the original signature of the signer is, makes the call based on the signature on the petition sheet. Your hearing examiner does not look at the registration card.
Objection, there's no evidence that the hearing officer disregarded the registration.
Well, he didn't. I don't need evidence, he just didn't. Well, he didn't. If counsel is saying he did, then...
Well, I'm not saying, but I don't know how you can say he did or he didn't.
Because we were at the hearing. I met Ross with the hearing.
Well, that doesn't mean that he couldn't look at it afterwards, right?
They were on his laptop.
Well,
Okay. Even if he did, let's say he did. He looked at it. He's not your handwriting expert. He's not the person you paid to make these calls. Your handwriting expert made the call and said the signature on sheet 4, line 7 is the signature your handwriting expert saw on the registration card. Overruled your clerk. Now we get this affidavit, and of course, for years, we've, depending on what side we're on, we complain about affidavits. You can't cross-examine them. You don't know what they were presented. You don't know if the sheet and line were filled in. You don't know any of that, and that's the weakness of affidavits. However, that's what we use. That's all we can use. And of course, I've used them many times myself. However, in this case, you have the person who signed the petition sheet saying that they didn't sign the petition sheet when your hearing examiner said she did sign the petition sheet. Now that's a quandary.
Not the hearing examiner.
I'm sorry, correct? Your handwriting expert. And then your hearing examiner overruled your handwriting expert and said, based on this affidavit, it's not a
The
good
signature in the affidavit.
Yes,
Yeah.
ma'am.
Mhm.
So the quandary I have, and I won't take your time to go through them all, but if you go through these 10, you will see the signature on the affidavit is exactly the signature on the petition.
Okay, thank you. Mayor,
So these 10 should be overturned, and the result from the handwriting expert should be restored. One other thing, the first two, your clerk ruled them bad and the handwriting expert ruled them good. The remaining 8, both your clerk and the handwriting expert ruled them good. The affidavit was brought in that said, that's not my signature, when the signature on the affidavit matches exactly to the petition sheet. These 10 should be restored. Thank you, ma'am.
Thank you.
Thank you. So the board's rules, as counsel said, have long allowed affidavits to come in to overrule even the handwriting experts' rulings on individual signatures. In this case, both sides extensively brought in the affidavits. The hearing officer very fairly applied the same rules to all of them. He had the registration records, he had, of course, the affidavits, he had the petitions, and in this case, we're specifically speaking just to these 10, all of these 10 affidavits state not just that it is not my signature, but that it is very seriously a forgery. We all know that signatures are out there. They're out there from past petitions in these districts. They're out there. And that is a very serious matter, and we ask the board to take it seriously. In this case, all of these affiants presented a driver's license or a state ID to the notary, which the notary indicated on these affidavits to show that I, the affiant, am in fact this person. Many of them gave copies. There are much clearer copies in the original exhibits that I'm sure the general counsel for the board has. But you can see them here. Some of them gave their driver's licenses numbers just on the affidavit itself, which we redacted in obeying the board's rules, but it was presented. I note that specifically 2 of them, LaToya Williams and the person whose last name ends in Larry, the names on the petition are not even spelled correctly. LaToya Williams is missing the last letter of her first name. She's also missing a considerable part of her last name. Larry, the last name, which is spelled Larry, is missing one of the R's in his last name on the petition. And then there's another one, I think her name is Geraldine something, where she writes very small, but as you can see, she has tons of room on the petition since she writes very small. She always spells her first name out and her last name out when she writes her name, as you can see from the affidavit many times. And whoever wrote this name on the petition knew to write very small, but didn't finish either name there. But regardless, we reiterate to the board, of course, the board can rule as it will and see all evidence, but this is not a de novo hearing. The hearing officer examined, took everything, all evidence, into account, and made findings of fact. And again, we bring to the attention both the very serious charge by each of these affiants that these are forgeries. And that's a serious allegation for these affiants to make under oath. And secondly, I just bring attention to the fact that each of them presented a driver's license or state ID to say that I, the affiant, to prove I am this person. Thank you.
Madam Chair, just,
Yes.
council brings up a really good point. And I would ask you to look at the driver's license and the signatures on the driver's license, which match exactly the signatures on the petitions. I mean, if you look, 1, 2, 3, look at the fourth one down. It's Jeremy McMorris. If you look at his license signature and you look at his petition signature on the first line and you look at his affidavit, they're all the same. It's your handwriting expert is an expert for a reason. He made the right calls here. Your binder clerk made the right calls on 8 out of 10. These 10 certainly should be restored.
Am I correct that the hearing officer did reject some of these affidavits?
Correct, rejected 6.
What were his reasons for that?
Thought the signature was too similar. Thought the signature was too similar.
Yes.
And he had the registration records in front of him as well.
I will note in the opinion, in his recommended decision here, the only basis provided is that the signature is somehow not, quote, substantially similar. And the real basis for this motion and our arguments is that, in fact, the hearing officer in this case applied the incorrect legal standard and what's required by this board's precedent and frankly what's been affirmed by the circuit and appellate courts, as we cited in the motion, that was not, it's not a valid legal basis, and on its face, as was described by counsel, it flies in the face of any rational conclusion. So,
I would, in response to that, point out that the record reflects there were at least two indications in the transcripts where it does show that the hearing officer was reviewing the affidavit signature against both the registration signature and the petition signature. Specifically from the January 7th transcript, lines 17 to 19 on page 12, and then the January 9th transcript, page 78, lines 4 through 6.
Yes, Mr. Glasgow, can you chime in here on these two issues?
So on the first issue, Ms. Jacksack is correct. It was both Rule 6 and 8 in bold font, starting with all caps were important. I do have the rule that watchers of the records exam have to preserve things during the records exam. This board does have a history of strictly enforcing that rule. And the indication here is that those 6 were not preserved. As for these affidavits, I have already shown at least 2 instances in the record to show that the hearing officer did have the registration clips available to him and was comparing his affidavits against them. Clearly, he was making his discretionary calls. He rejected 6 of the affidavits and he granted 10 of them. So he was well aware that some of the affidavits might not be legitimate, but he made the decisions that he made. And I guess it's just up to the board then to see if you find a substantial error in his decisions. I would also point out that the board's handwriting expert, who is a duly credentialed and very experienced forensic document analyst, she would tell you that there is not 100% scientific certainty with the rulings that she's able to make with these particular kinds of cases. Not 100% scientific certainty. She's using one petition signature and comparing it to one exemplar signature, which is a photocopied scan of the original registration signature. So she does her scientific methods when she makes her rulings, but I do not believe she would tell you that she's able to make 100% scientific certainty with them, which is why we do sometimes see things go the other way. She also was not aware of the existence of these affidavits at the time that she was making her decisions. She did not have the signature exemplars from the affidavits to assist her with the process.
So just for the record, the handwriting expert has the registration cards and the petitions, signatures.
The hearing officer has signature clips that come
Right.
from the registration cards.
But the handwriting expert only has the signature clips and the petition. But the hearing officer, as pointed out in the transcripts, had the signature clips, the affidavits, and the petitions.
Correct.
And the license?
And also in some cases, driver's licenses.
Right.
Right, okay, thank you.
Well, so Mr. Lasker, if I hear you correctly, I mean, I'm persuaded with respect to the first issue already, but with respect to the second issue, I mean, just what you were, if I hear you correctly, what you were saying is that it's the job of the board to determine whether the hearing officer, not necessarily whether they, let me step back. The job of this board with respect to these signatures is what? Can you articulate that one specifically?
The election code does not specifically set forth any particular duties or authorities of the hearing officer. This board and some other boards throughout the state do retain attorneys to serve as hearing officers. But their reports to you are merely recommendations. So this is like a de novo review for you today, even though it is a question of fact as compared to law on this kind of analysis. So the board is free to rule the way it wants to rule today. It does have a precedent of giving deference to its hearing officers on the discretional rulings that they recommend. But the board is not bound in any way by the hearing officer's recommendation.
And I get that. And are we looking to review the signature itself or the process by which the hearing officer examines the signature?
You did.
No, that's my question. Are we evaluate, we can have any ruling we want to. This is the bill we're reviewing for us. My question to you is, are we looking more at the process or are we looking at the actual, what we see in front of us relative to the signatures themselves? Because I'm going to be very honest. I'm looking at some of these things, I'm looking at the affidavit, and I get where some could be right, some could be not right. I'm looking at one in particular that struck me. Latoya Williams. You know, what struck me about this was that even in the address, I mean, and maybe I'm going beyond the scope, if I am, please tell me, but I'm looking at the address as well to see how the address is written, to see if there's a comparison there, since you presume that that's written in the hand of the person inside the signature, and you have 8 with a raised E, 116th Street. I mean, I don't find that to be a huge coincidence if you're saying that this is a forgery. So I guess that's what I'm getting back to. But some of these, it's a judgment call, and that's what I'm asking. Is it up for us to look at the signatures, or is it for us to look at the process, to defer to the hearing officer?
Well, all of the above. You've got the authority to look at it all.
Okay. And what would be our?
I think, but one thing to consider is we have heard argument from Mr. Jacksack as to, why would these people sign this affidavit if it wasn't true to put themselves at risk of perjury to provide a driver's license to make it abundantly clear that they are the signer.
Okay, but there's another question. That's what the problem, I think, with Mr. Olson said with respect to affidavits. They can't cross-examine them, right? And so there is one other option. I'm not saying this is the case. I want to be very clear about this, right? But it says that they saw a particular petition. I don't know what petition they saw, right? And that has not, and I can't ask the question, what petition did you see? Let me see the petition that you saw when you signed this affidavit. And I'm not saying that they did not see the correct petition. I'm not saying they saw an incorrect petition, but that's the challenge with affidavits. Because looking at it with my eyes, a couple of them, relative to looking at the entirety of it, some of them seem very, very close. And you can imagine, having the environment in which petitions are circulated, be it cold, be it rain, be it on the back of the clipboard, be it walking down the street. You can presume some variability, but on some of these, it seems to be a bit, that's why I'm asking. So if we had an option with respect to this, what is our, what are our options to be? Is it for us to make the determination signature by signature, or could we remand for another review?
Both of those are options. I would suggest that because these are to be expedited proceedings, we would not remand for a second review by the same hearing officer as a matter of time and as a matter of, he's done his review, he's given us his opinion. He might, maybe even change his mind on something, but why?
One option is to just defer any action on this until the end of our day here. And that would give the commissioners the opportunity to review this a little bit more carefully.
That would be helpful.
Okay.
If I could, counsel, we have here the copies of the affidavits and the petitions, and in some cases, driver's licenses. We have not been presented with copies of the signature clips from the registrations.
We can pull those up on your computers.
Would counsel been able to provide those to us?
We have them.
Okay, I was just asking this question, would counsel have been able to present?
No, we provide the signature clips to the hearing officers. They are available to the parties to review during the hearing, but we do not let the signatures leave the building. So they're available to you on your computer screens today. We have a printout copy that's in the original case file that could be.
But I wanted to put on the record that they were not able to provide those.
That's correct.
Thank you.
May I add one comment?
Sure.
And specifically speaking to Commissioner Swain's concern, so we exchanged documents and witness lists on a Friday, and then we had a hearing the next week, except it was continued, and so I didn't present any of the objectors' affidavits until Thursday. And so counsel, of course, was free to enter or present any evidence, including witnesses, even if they were not on their initial witness list in rebuttal. But they chose not to present any evidence in rebuttal. They didn't present even testimony from the circulator, for example, to say that I was there, or any counter affidavit, or any other evidence.
Ms. Jackson, may I clarify? On that Friday, you're saying, did you do an exchange of these affidavits?
Yes, we did an exchange of the affidavits and the witness list on a Friday. Then our hearing started that Tuesday, but we didn't even get through with the candidate's full case in chief, and they went first since they were under. And so we didn't start the objectors portion of the case in chief until Thursday, so a full week after we exchanged documents. Thank you.
Is it the consensus to defer this until
Let's table this.
It's the end of the call, yeah.
until the end of the call?
Yep.
Thank you. I would just encourage the commissioners to look at these 10. We don't have the binder clips, as Mr. Lasker said, but your handwriting expert did, and he made the initial call after your clerk made the initial call. And you please look at their affidavits and look at the signatures. That's all I ask you to do.
Well,
Thank
Mr.
you.
Edelson,
Yes, ma'am.
what time can you be back here?
Mr. Lasker will be back.
Well, we got,
Yeah, and Mr.
I would-
say, he's
Mr.
gonna be
Lasker will
here
be here
all the
too.
time.
I would estimate
Whatever
somewhere
time you say.
between 2 and 3 o'clock,
Yes, ma'am.
okay? Okay.
Is that convenient to Ms. Jackson?
Yes.
Thank you to the board to moving this up, and to other council who allowed us to be moved up ahead of them. I appreciate it. Thank you.
We're going through the Rule 20 hearings at this point, and I'm going to start in numerical order again, unless there's a council here has a pressing word. No? Okay. So the next one is 20 EB-CON-002. Kyle Shea, Jacqueline Gianni, and Corey Seeley versus Keena Collins, candidate for representative in Congress, 7th Congressional District, Democratic. And can I have the appearances, please?
Scott Erdman, E-R-D-M-A-N, on behalf of the objectors.
Good morning. Andrew Finco for the candidate, Keena Collins.
You pull them a little closer.
And turn them on also.
Turn them on.
Thanks.
Is this okay?
Can you get a little closer? And And this is the objectors' Rule 20 motion?
Yes.
Okay. Mr. Brickman?
Good morning, Madam Chair and members of the board. What we have here is a case of a candidate and her entire campaign undermining the integrity of the entire process. So the petition circulation starts with a voter placing their signature and their address where they reside on the petition, and they're certifying that information. That's what the code asks them to do, and that's what they do. After that point, change is not allowed. Any change to that after the separation of the circulator and the voter nullifies that certification, because the voter is not part of that process once they walk away. The red herring in this case that council I'm sure will bring up is that the circulator can write the address of the voter onto the petition, and that's fine. They can do it right there in front of the voter when the voter signs. But it doesn't then become the property of the circulator to do with what they will anytime after they walk away from the voter. The info on the petition is the property of the voter. The statute and case law have been clear on that, and in fact they tie that to a vote down the road, which is what Chicago law says, why you can't sign another petition. You've tied yourself up. This is your signature, this is your information, this is your vote. And it belongs to the voter. The statutes speak to the changes of info certified by that voter, and what you can do with that after that meeting between a voter and circulator ends. And it's the certificate of deletion process. The statutes say you have two choices: accept the line and present it as part of your nomination petitions and have it be subject to objection by any registered voter with an interest in seeing the election laws upheld, or strike it completely. The candidate wants to say that the statute is silent on this point, and it obviously isn't. The statute says, here's what you can do: strike it or leave it alone. They gave us instructions on what we can do. The fact that they didn't go further and address any other changes doesn't mean anything. They told us what we can do: strike it or leave it alone. The other item that council will bring up is that changes can be made prior to a notarization. It's simply not the case. The candidate has misread the case cited in our Rule 20 motion, and the case law relied on throughout the hearing, and that's the McDonald-Kowalski case that was heard by the Chicago Board of Elections and then was appealed all the way to the appellate court, and found that the activities of this candidate, of the candidate in that case, which are exactly the activities of this candidate, were fraud. What the candidate seizes on is a portion of the opinion in that case where a circulator named Hamilton testified before the board that all of the changes that Kowalski McDonald made to his petitions were made after he had them notarized and turned them over to the candidate. The candidate somehow has twisted this around to be some type of justification that any changes prior to notarization are fine. But that's not the case. You go back to the initial point, which is that the voter appeared before the circulator, they affixed their signature and their address, and the language right above it says, I certify that I reside here. And once they walk away, that certification is finalized. It's not the purview of anyone to change it. And
Mr. Urban, where do you see that certification?
I certify, we the underside the language above, do hereby petition, and then the code says that they're certifying that they reside at the address.
Where? Go. In 10 ILCS 5/7-10. Say it again, 10?
Yeah, 5/7-10.
5. You read the language?
Just one second. The language is that they shall be signed by qualified primary electors residing in the district. And when they place their name on there, that's what they're stating. By placing their name on it, that's what they're certifying.
Well, what about the reference?
The entire line.
You say
That they.
by signing this,
Right.
by signing this, that you're saying that you're a qualified elector of this little subdivision, all right?
And his residence address shall be written or printed. That's what the election code requires the voters to do.
And notice, it doesn't say it has to be written by the voter. And case law has established circulator or anyone else, you can pre-print these petitions however you want.
Right, but the voter places their signature next to that information to say, this is who I am, this is where I live. I'm a qualified registered voter here. And then when the circulator walks away from that voter, it's done. The voter's information as placed on that petition sheet has been placed there by the voter and next to their signature, and it's their line, it's their property.
Do you have any other, I'm just trying to move this along, any other arguments?
Yes.
Okay.
Yes. So, in the Kowalski case, both the Cook County Officers Electoral Board found that any changes to that information by the candidate or by the candidate's team is fraud. Ms. Kowalski was crossing out addresses and putting in new addresses as she looked them up. That's exactly what we have here. That's exactly what the campaign field director admitted. It's what the candidate admitted under oath, is that they would look them up and that they would change them.
Is that before or after, in that case, the changes were they made before or after the circulator certification?
In Kowalski?
Yeah.
Kowalski was completely after the fact.
Madam Chair,
And
I just want to point out, we've discussed the McDonald case. He is referring to the McDonald case. The candidate in that case was Jan Kowalski McDonald. So I just want to make, I just want to make it clear that we're talking about the same case.
I apologize. But what Ms. Kowalski was doing was changing addresses so that the registered address of the voter would appear on the line instead of the address that the voter signed and placed on the petition as where they reside, as required by the statute.
Isn't that driven probably by the affidavit at the bottom saying that their respective residences are correctly stated and set forth above? And that's what makes the signature, the notarization, the kind of tipping point?
No, above, they have to say that they reside at the address listed below.
Well, I understand
That's what
that, I understand
saying
that, to keep, but in this case, this Kowalski McDonald case that you're talking about seems to indicate or has been argued that the issue and how it's distinguished from this case is that in that case, the petition had been notarized, and in this case, petitions had not been notarized.
No, and that is the mistake that the candidate is making and one of the mistakes the hearing officer made. The
Is that not how it's trying to be now distinguished?
No, in the Kowalski case, she never admitted that she did it, and they had to prove that she did it. And one of the ways that they proved that she did it was they had Mr. Hamilton, one of the circulators, come in and testify that all of the changes on his petition sheet occurred after he completed his process, which was the notarization. The board found that because she had changed those after the notarization, all of his sheets would be stricken. And that was their justification of striking all of those. Independently and separately, it was the finding of the board and the appellate court that what she did was fraud. Not because it happened after the notary. That was specific to Hamilton's sheets. What they found was that that very action that she took is fraud, and they even addressed the fact that the notarization and the circulator being able to write in the address, these were all red herrings that had nothing to do with the fact that the candidate changed the petition after the fact. And the board said that, in short, this is what the court said, in short, we agree with the board's unequivocal condemnation of the conduct at issue in this case. That conduct called into question the accuracy of the address information provided by petition signers and undermined the integrity of the petition process. It was also fraudulent. We reject Ms. Kowalski-McDonald's assertion that such conduct is in any way permitted by controlling provisions of the election code. She's not allowed to do it. Ms. Collins is not allowed to do it. And what we have with Ms. Collins is, not only did she admit that she did it, she had her field director testify under oath that it was their process and their practice to do this. That's what the circulators were instructed to do. Go get the signatures, come back in, we'll check them, and if there's any change, we'll make the change. And her stated reason for that was to put the best. Hang on, I'll get you the quote here. She said, people forget to change addresses and we would change them. And she was asked why, and she said, to make the sheets as accurate as possible. So we have an after the fact alteration of these petition sheets to change them, to present to the election authority so that they would be as accurate as possible. And this is just as it was in the McDonald-Kowalski case, an attempt to short-circuit the process and say, we're going to give you all these and we're going to change them so they're good, so that they'll survive any type of scrutiny. And the court said that you can't do that. It's fraud. It undermines the integrity of that voter placing their name, their signature, and their address. And the fact that the address can be put down there by the circulator is red herring. It doesn't matter.
I'm going to turn it over to Mr. Finko for his position on these issues.
Good morning, thank you. The simple answer is the objectors failed in their burden of proof. The objectors showed a petition sheet of a candidate, and there was a cross out of approximately 20, I think the hearing examiner found, addresses that were changed. However, the objector did not offer any evidence to identify who made the change, when the change was made. There was an argument that, well, some of these were made by voters, and that's what the testimony confirmed. This is a competing candidate, Christine Schanbacher, who was identified as the objector's wife. She's got the same thing on her
I'm gonna
sheets.
object.
Does,
This is
Okay.
absolutely, it has no relevance to what the hearing officer found. Ms. Schombacher's petition sheets have no relevance here
Okay, you
whatsoever.
can address that afterwards. Mr. Finko, please stick to the relevant evidence, okay?
Yes.
And
Thank you.
what was admitted into evidence.
right, and the point was that my statements just now, regarding Ms. Schombacher's paperwork is no different than what the hearing examiner heard throughout this hearing. Nothing more than the statements of counsel, the inferences, arguments, whatever he may have guessed, but there wasn't a shred of evidence offered by the objector to support either that these changes were made at some point improperly or were made after notarization or any other way, that they were not made by the voters, for example, while they were signing. There was one affidavit submitted from the objector, Vernon Coleman, who said, well, I wrote down an address on my petition sheet. And then he says, I didn't see where or how that address was changed. The candidate did have a field coordinator that was looking at these to get some feedback. I mean, this was a first-time candidate going above and beyond, trying to do the best she could to get signatures of registered voters in the district, because that's what her goal was. The field coordinator did say that they were checking registrations, and then there were a handful where either the voter sometimes changed or sometimes they would ask the circulator to correct before it was notarized. There's no other testimony in the record other than that. And that was, as the hearing examiner found, there were 20 incidents of that situation, which some may have been by a circulator, some may have been by a voter. Nobody was keeping track of it at that point. And keeping it in perspective, this is a candidate that submitted 3,215 signature lines. At the end of the day, she had 638, I believe, over the minimum. This was not a candidate that needed to resort to any type of fraud, any type of unethical conduct. This was a candidate that had a well-organized field team of volunteers. They were meeting at canvass locations weekly. They were turning in their sheets weekly. They were getting them notarized. This was everything that they were doing the best they could. So factually, I think it's important to note this is the objector's burden of proof. When they make the very serious accusation of fraud, they better back it up. And there was nothing behind the arguments of counsel to back up any of that. The second point was that the Kowalski decision from the Electoral Board is a world apart from the facts that were presented before this hearing examiner. Kowalski, as is noted in the hearing examiner's recommendation, included a lot of factual, specific information. Who did what, when, where, how. There was a handwriting expert that testified for hours about the handwriting on the petition sheets. The candidate testified, Kowalski said, that was not my handwriting. The handwriting expert said that was her handwriting. The hearing officer found that Ms. Kowalski not to be credible. There was a weighing of the evidence. There was a balancing of the interests. And in that situation, the hearing examiner said, well, let me take the least restrictive approach. And he said he removed 753, there was, I think, 753 addresses on 378 sheets. And again, a world of difference from the 20 lines here that had reflected an address change of unknown origin, because unknown, it was not proven by the objector. So the Kowalski decision from the Electoral Board is totally distinguishable on many bases. I would ask that this board adopt the hearing examiner's recommendation. Thank you.
Mr. Bergman? would you-
Absolutely.
Okay, just 2 minutes, if
Okay.
you could limit.
Mr. Finko completely misstates what happened with the differences between these two cases. There were handwriting experts, there was testimony in Kowalski. It's because she denied taking those actions. Here, as acknowledged by the hearing officer, the candidate admitted taking the actions, the campaign field director admitted instructing the circulators to take these actions. The affidavit of Mr. Coleman proves that the circulators took these actions outside of the presence of the voter. And what Mr. Finko says is a complete lack of evidence is he seems to feel that the only evidence there is a handwriting expert or testimony. We have evidence here. We have the petition sheets which are entered into evidence at the very beginning. We have the objection sheets objecting to these, sheet and line, that were entered in at the very beginning. And we have the testimony of the candidate and the field director admitting to taking these actions and admitting to instructing all of their circulators to take these actions. And it's not 20. Council has continued to misrepresent that number. It's not 20. It's 70 specific points where addresses or cities were crossed out and changed. 70. And part and parcel of this is where the candidate went back and changed initials and hash marks to cities. It's where she crossed things out and initialed them. And what the board should look at is not only the fact that they've just admitted the fraud. Kowalski defines it as fraud. The candidate and her field director admit that it was their process, their practice, their instructions to their circulator to commit these frauds. Okay? And then the rest of the evidence shows that what they did is they plopped them down in front of her, and this candidate changed anything she could change to beef up her petitions and make them as accurate as possible. Now, there's a de minimis argument here that is just ridiculous. The hearing officer retreats, he acknowledges the actions that are described, that are found to be fraudulent in the Kowalski case, and then backtracks to say that they're somehow de minimis, that even without the changes, the petitions would have been okay. Well, that's not the question. The question is, did you change them? Did you pierce this action of the voter placing their name and their address on this petition, and then alter it for your own good? And Kowalski says that's fraud. And the evidence here is, by their own testimony, the campaign committed these acts of fraud.
Thank you.
Council, I think you were pointing to 10 ILCS 5/7-10?
Yes.
Okay, which calls for, it states that, we, the undersigned members of an affiliated, do hereby, and say that they reside in the district. They're not stating that they reside at the particular address. It's in the circulator's certification that these are the correct addresses.
That's fine.
Okay, so the statute doesn't say that the voters are stating that by their signature, they live in this district and at this address. They're just saying they live in this district, and then asking them also supply an address next to it.
I think that's a reach. I think that the entire process is based on these voters placing their name and address.
It's what the statute states.
Well, case law extends that. That's the whole purpose behind a voter registration objection in sheet and line that this board and the hearing officers rule on through the Rule 8 process. Are you a registered voter at that address? And that address is placed there by the voter, and it can't be changed by anybody. It can either be deleted or left alone.
I don't see that in here, and the testimony, as I understand it, the candidate admitted that these changes to the address, which is just apparently adjunct information on the petitions, were changed before the petition sheets were notarized. Is that correct?
Actually, the candidate admits that some of hers were made prior to and some were made after the notarization. But what Kowalski says is that that doesn't matter. Changing the information placed on the petition by the voter is fraud.
Well, I don't read Kowalski McDonald that way, but all right.
I'd like to hear from Mr. Leister on these issues.
Are we under the proper understanding the appellate court decision is unpublished?
It is, and it can be, and while it can't be cited as presidential, it can inform and be persuasive before the court. Also, the board's own rules allow it to not strictly follow the rules of civil procedure.
Okay, but we're not bound by this appellate court decision. I also disagree with the interpretation of it. There is a Cook County Officers Electoral Board, it's a published decision that came with judicial review and then the appeal in that case. In that case, we're talking about 753 addresses on 378 signature sheets were changed. With testimony, actual testimony from one of the circulators that it happened. He didn't make those changes and they weren't there when one circulator said the changes were there when he did notarize, the second one said they were not. I don't see anything in the election code that does say that the voter certifies the address. There is very clearly a certification under oath by the circulator as to the accuracy of the addresses. I think that the commissioners might want to know that in common practice, I've seen a lot of petitions come through with changes on them. Sometimes someone writes 121 Main Street, but they actually live at 112. Or they live at 1234, but they only write 124. And the campaigns, this is not, the Kowalski campaign and this campaign, from my personal experience, are not the only ones that have had a process where circulators submit their sheets unsigned, candidate reviews, well, the party reviews, campaign reviews the signatures and addresses, makes changes as the circulators come back and they're certified. It is my opinion that those changes should be made before the petition is notarized and the circulator is sworn to certify the addresses. However, as the candidates pointed out in the case at hand, the objector has not provided evidence to show us which of the sheets may have been done before or after. So there is no identification. The candidate did apparently testify that, yeah, maybe some of these were done after certification, but we don't know which.
I would like to point out the very language from the Kowalski case where the court says, her primary argument on appeal is that even if a candidate were to alter addresses in the manner described in the board's decision, that would not constitute a pattern of fraud justifying the striking of entries or pages from the candidate's nomination petition. According to Ms. Kowalski, McDonald, because the conduct at issue involves no false statement, the board's decision essentially establishes a new pattern of integrity standard. We do not agree. They're clear that this is fraud. They state so in their opinion.
I do think it's inappropriate to say it's an unpublished opinion as though it's precedential. It's proper if it's the law of the case, but this is not the law of the case.
Okay. I think we've heard sufficiently from the parties.
I do have one question.
Yes.
Mr. Lasky, you made a comment, very brief. I want to make sure I got this right. So, the notary stamp seals the petition, effectively, meaning at that point in time, the petition should not be altered.
That's my opinion.
Right, other than potentially numbering it or something of that nature, right?
Right, it's set in stone for the content involved in the circulator's affidavit, which does not, for example, include the page number.
Got it, okay. So, you said, testimony was said that some of these petitions were altered after they were signed, right? I mean, after they were notarized.
I think that was Mr. Bergman stated that, or that the testimony was that some were altered before certification and some after. Is that right?
The candidate herself identified address strikes and changes on 5 of her sheets. When she was asked if they were done prior to or after notarization, she said typically that they were done before. And after repeated questions, she finally said probably 3 before and 2 after.
Okay. Mr. Finko, just address that. Is that correct, or?
My recollection, I do not have the transcript, was that there were 3 types of changes that were being made. The strikeout attempt, and it was an attempt because the certification of deletions wasn't included, was the part that was done after the notarization. She was putting a line through the sheets where there was a post-it note on the page that said not found at a certain line number. So she was going to clean up her petitions and put in a certification of deletions, but through inadvertence, the certification didn't make it into the nomination packet. So there were strikeouts with her initials. And she went through and initialed after you know, when she was doing her strikeouts, she did go back and initial the prior changes. But the address part, unequivocally, the testimony was addresses were only corrected prior to notarization at the field canvas locations. She did not make the address corrections after the notarizations.
That's a very long answer to a very short question. And the candidate admitted under testimony that she changed some before and some after. But again, the notary issue is a red herring.
Well,
Under
let
that.
Let me finish my point. How about we do that? Mr. Lasker, so presuming that the record says that some of these sheets were, addresses were altered after they were notarized, that effectively would render them, would that effectively render them null and void, those sheets? If we knew what they were? Since they were altered after the notarization.
Well, there's no binding law on this, so the board would have to make its determination as to what the proper remedy would be.
Okay.
You know, a lot of the changes that we're talking about are where, for example, I've seen many, many instances where people put CHGO in the city box. There's the strikeout, and it says Chicago above it, and then the candidate's initials. I think this might answer some of the difference between when Mr. Finko says there's 20 examples of this and Mr. Erdman says 70. I think it might be the vast quantity of these are OP is crossed out and replaced with Oak Park.
Okay.
So I would recommend against finding that that's fraudulent conduct.
Okay, I'm not speaking to that, I'm talking about the address
But
itself.
actual address changes,
If they were done after the note.
the board would have to decide, should we strike just that one signature
Or the page.
or the page? Or make its decision that it was not something worth striking because now you're disenfranchising the voter who did sign the petition. There's no argument that the person signed the petition and wants to support this candidate. We don't know why the person put down an address other than where they're registered to vote. There can be a lot of reasons for that, including, as I would point out, sometimes people just make a typo on their own address.
Okay.
So I think it's, all these factors need to be considered.
To clarify, it isn't 20. The 70 that I'm referring to are 70 places where the addresses were changed. It's situations where Karen Long, who put down, I live at 5462 West Racine Street, is crossed out by Casey and moved to 953 North Parkside.
So Mr.
Now, under Mr. Lasker's theory, Mr. Holliday's job is about to get exponentially more simple because we will no longer have voter not registered at the address objections because anybody in a campaign can go through, cross out the address that appears on the petition, look up the registration address and place it there in their own hand. And nobody will have the ability to object to a not registered at the address that appears on the petition. That's what we're saying here, is that the campaigns can go ahead and cross out an address, put a registration address, and avoid any scrutiny as to the registration address of that voter. And that is what happened in Kowalski, and that is what happened here. And that's simply not the case. And while you're not bound by the precedent of Kowalski, it's illustrative of what the law is, and it can be taken as persuasive evidence. This is fraud. There would be no need whatsoever for a sheet and line examination on voter not registered at the address on the petition if we allow every campaign and every candidate from this day forward to go through and change every address that they found a voter not registered at and change it. And there are reasons that a voter puts down an address. They can change and assume that because they updated their driver's license, their registration changed, and they can be wrong. They can move and they have not updated their voter registration. But those are sheet and line objections that this board and Mr. Holliday's crew goes through and invalidates those signatures because they're not registered at the address that they placed on the petition. And the process put forward by Mr. Lasker would allow every single candidate prior to circulation, as if that's the point of no return, to go through and alter a voter's information that they have either placed themselves or had placed by the circulator on their behalf, and change it to whatever the candidate feels is most appropriate and most strengthens their petitions so that they could withstand an objection.
Did the objectors specifically identify which ones, which lines were amended after the circulator's petition? Is there any specific evidence?
Mr. Coleman's affidavit said this was changed after I placed it on the petition and after that they left.
That was one voter.
Right,
Who was
and our contention is that, again, is that this notary issue is a red herring. That isn't the point of no return. The point of no return is when the circulator walks away from the voter. The voter has given the circulator and the campaign their information, and that's done.
Okay,
And
so
it
you're
can't be
asserting
changed.
once the circulator walks away, once there's that separation between the voter and the circulator should not be able to make any changes.
Correct. And that's what Kowalski says.
Okay.
And the testimony of the candidate and her field manager was explicitly that was the process of this campaign. That their process and practice was to alter voters' addresses after the fact so that they could put forward the best product possible and withstand an objection.
Okay. Are there any further questions? Okay. I think we're ready to go on your Rule 20, and I thank you for your arguments, but I do think that the Rule 20 should be denied for a number of reasons, and at this time, I'm requesting, is there a motion to deny Rule 20?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The Rule 20 is denied. At this time, I'm going to jump over to the final decision. In number 1 on the agenda under letter E, in this matter, in Kyle Shea, Jacqueline A. Gianni, and Corey Seeley versus Keenan Collins, 20 EB CON-002. Is there a motion to overrule the objections and adopt the hearing officer's report?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and
Madam Chair,
yes.
I have a written decision memorializing the actions taken today by the Electoral Board in this matter. I'd like to remind the parties that pursuant to Section 10-10.1 of the Illinois Election Code, there's now a 5-day judicial review window. We will serve this on you if you can stick around. We'll get a photocopy made in just a few moments. If you can't wait, then it will be placed into the mail to the respective addresses of the objectors and candidates for service on this 10-10.1.
Thank you, both of you.
Thank you.
We will then now proceed with the next case, Rule 20 case. It's 20 EB RGA-008, Ida Walker and Anita Archibald versus T. Ron Ty Braddock, candidate for representative in the General Assembly, 9th Representative District, Democratic. Are the parties here? Oh.
Yes,
Oh.
I'm back. Good, bad, or indifferent.
Want to stretch your legs
Here I am.
maybe, or?
I've been stretched.
Oh. Okay, let me just.
By the whole cycle, not.
Let me just.
We're almost there.
Can the parties please identify themselves for the record?
Scott E. Erdman, E-R-D-M-A-N, on behalf of the objectors.
And Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate.
Mr. Erdman, this is your Rule 20, objector's Rule 20 motion?
Yes.
Okay.
So we have two issues here. One is the hearing officer manufacturing of a remedy to a problem that didn't exist. The initial final report in this case showed that 1,579 signatures had been reviewed for office with a cap of 1,500. That same report was delivered to all parties. Unfortunately, the total down below that said that how many signatures the candidate was short showed 38. Included in the 79 signatures above the 1,500 that had been reviewed were 21 good signatures. So those 21 added to the 38, that the candidate was actually 59 short. The objectors brought this to the attention of the hearing officer. On the day of the evidentiary hearing, for the candidate to present evidence to recoup and rehabilitate those 38 signatures. We went through the entire process. I believe 58 pieces of evidence were presented by the candidate, and further evidence, which was just screenshots of voter records from the website of the board that weren't certified, were also submitted, and the hearing officer chose not to admit those. They weren't certified. But at the end of the day, out of the 58 pieces of evidence that the candidate put forward to rehabilitate 38 signatures, they rehabilitated 36. Now, the candidate said, wait a minute, that's the wrong number. The real number is 59. We deserve to be able to go after 59. The hearing officer's remedy that he crafted was to extend by over a day the amount of time that the candidate had to gather evidence and present for this Rule 8 evidentiary hearing. The remedy doesn't fit whatever the harm was to the candidate. The candidate came in with the goal of rehabilitating 38 signatures. They presented 58 pieces of evidence, and they only rehabilitated 36. I fail to see the harm of someone who's been given a clear goal, has been given the amount of time that is appropriate to achieve that goal, and they came in and they missed it. They fell short. The hearing officer extended that time as a remedy to a harm that didn't exist. We feel that extension of time was improper, and that any evidence that was submitted at the second evidentiary hearing should not be considered by the board. The follow-up, the second item was, within the body of our objection, we made objections to circulators, affidavits by sheet and line within the recapitulation sheets. Those needed to be ruled on. It was pointed out in an email by the objectors to the hearing officer that those were outstanding and that they needed to be ruled upon, and the hearing officer decided that those had been waived because we rested at the Rule 8 evidentiary portion of the hearing. It's the objector's opinion that those are part and parcel of the objection as a whole, and that they deserve to be ruled upon here.
Thank you.
Thank you very much. I just want to note that this was a is a very seasoned, experienced, and qualified hearing officer who provided a very detailed and thorough report and recommendation in this matter. This isn't something where it's just, I think this and this. The report is quite detailed, it's quite thorough. Obviously, as the candidate, we don't agree with every single ruling that didn't go our way, just as I'm sure the objectors don't agree with every single ruling, as was mentioned before, but providing a detailed decision that fully describes his legal reasoning and justifications, and ultimately for his recommended decision. And those are very well justified. In this case, the first issue that was raised is about the board's error in the first petition summary report and the summary of what number the candidate had to recover in order to obtain ballot access. And I think it's really important, and as the hearing officer aptly puts, this was raised initially at the outset of the first part of the evidentiary hearing by the objectors, because the objectors wanted to try and say, well, we got you, actually you don't have enough evidence at all, so you can't even proceed. And when that was discovered and inquired about, the candidate was allowed to proceed with the case that had been prepared for that day, and then upon actually discovering and confirming that the board's numbers were in error, that created a difference of the fact, as the hearing officer described and explained multiple times. At the hearing, once you raise the facts and the board admits its own error and says and establishes what the facts are, that's what they are. And the board, and pursuant to the rules, the hearing officer is absolutely within his discretion to extend certain deadlines and continue the hearing and allow for the presentment of additional evidence. First, the disclosure, prior disclosure. We couldn't just show up at the next hearing date with new evidence. Both sides had to disclose it, and in fact, the candidate disclosed gathered and disclosed additional evidence, as well as the objectors disclosed and presented additional evidence. And so the process was fair, was well reasoned, and for the whole sheet objection issues, I think it's pretty clear on its face. The hearing officers details the emails as were stated in his rulings and basis. To note about the change in the Notary Act, nothing cited in the Cook County Officers Electoral Board case stands for the proposition that somehow now the notary signature alone doesn't qualify as affirming the oath and affirmation on its face, without ever, on top of that, having argued anything about this and raising it now. And also to note that this board has adopted and applied the validity of the de facto notary doctrine in McCoy versus Mendoza, which is 15 EB MUN 010, and is adopted by the hearing officer's recommendation in that case at paragraphs 18 and 19. So even if it were possible to find that were to apply, this board would also take note of its past precedent in applying the other doctrine. And again, there's nothing in the record, nothing was argued, and every opportunity was given, 2 opportunities were given to make all of those arguments, and they were not done. So we would respectfully request that you adopt the hearing officer's recommended decision in this case.
Yes, the idea that these allegations were somehow waived is ridiculous. They're in the objection. Hearing officers step away from the hearing table at the end of hearings with undecided and unruled upon objections that are contained within the objection all the time, and then rule on it. To somehow say that our allegations required either testimony or affidavits or anything else is incorrect. It's on the face of the document. We've alleged the infirmity. It's alleged to be on the face of the document. The Notary Act, which was changed as of January 1st, 2018, 3 years after the McCoy versus Mendoza case, has been changed to require the seal. Now, all of the other substantial compliance cases that candidate would have you look at are from when the requirement was a seal and a signature. Okay, well, they said, okay, as long as you have one, then you've got substantial compliance, and that's what the practice has been. Currently, the only thing required by the statute is the seal. And if you don't have the seal, you can't have substantially complied because you've done nothing.
Mr. West, your input here.
Yeah, it's very incorrect to say the only thing required by a notary act is the seal. This board has, since long before this amendment that we're talking about, has still excused matters that are related to mandatory requirements under the Notary Act. For example, under the Notary Act, you have to be a notary. You have to have a valid commission. And in some cases in this Electoral Board's history, it's actually excused the fact that the notary on the petition sheets did not actually even have an active commission at the time. That's just one example of the several situations where we've excused missing dates in the jurat, so forth and so on. So, first of all, I don't agree that anything has changed just because the Notary Act was revised. For reasons including the fact that this board has previously found that the penalties set forth in the Notary Act are to be applied under the Notary Act, and this board has, I believe, properly determined it's got no authority to enforce the Notary Act. So it has found substantial compliance, not in every situation. The board's history is if there's no notary signature and no notary stamp, the board has not counted those as valid sheets. But if one or the other is there, then the error has not been held against the candidate. Secondly, with respect to Mr. Erdman, I don't understand why he's arguing in his Rule 20 motion here today that the hearing officer didn't rule on these particular issues. The email correspondence and other statements by the hearing officer are in there, and then he goes on to say that even though they didn't put forth any evidence on these matters, he cites the prior cases, the notary putting the wrong name in the jurat does not invalidate the petition sheet, the failure to sign the sheet when the notary stamp was present, so forth and so on. He's providing the board with his recommended rulings here. So it's in his written decision. And the only thing he didn't do was allow the proofs to be reopened, the case.
Any further questions? If not, I think we thank you for your respected arguments. But for all the reasons stated by the hearing officer and Mr. Lasker, is there a motion to deny the candidate to 20 motion?
So,
Is there a second?
Second.
All those in favor? Motion passes, and I will go directly to, again, the final decision in this matter, which is number 2 on the agenda, Ida Walker and Anita Archibald versus T1 Ty Craddock, 20 EB RGA-008. Is there a motion to overrule the objections, adopt the hearing officer's report and overrule the objections?
So moved.
Is there a second?
second.
All those in favor?
Aye.
Motion passes, and the candidate's name will appear on the ballot.
Madam Chair, I can have a written decision to memorialize today's actions by the Electoral Board. Commissioners could sign it now, we can make part.
For the record, just to note, I believe you, the motion made was to deny the candidate's Rule 20 motion. I believe it was the objector's Rule 20, just to clarify for the,
Do what?
yeah.
Thank you, noted, and is,
I move to amend the motion as stated.
okay, to refer to the objector.
Which was your original intent, is that correct, Commissioner?
Yes. Okay,
So we will serve the decision today if you can wait for copies, otherwise we'll serve it today by mail. Either way, that's in compliance with section 10-10 and 10.1 of the Illinois Election Code, and it's 5 to 8 o'clock for the issue.
we will now proceed with the next case on the agenda. In the case of 20 EB RGA-009, Ida Walker and Anita Archibald versus Aaron Turner, candidate for representative in the General Assembly, 9th Representative District,
Democratic.
I think we should
Move. Shake it up a little bit.
things up. Hold on 1 second. Is it correct that this is the candidate rule 20 motion?
Objectives.
Oh, it's supposed to be objectors.
It's mistakenly captured.
Right.
Yep.
And Mr. Erdman, you represent the objector?
Yes, objectives. Ida D. Walker and Anita Archibald.
Mr. Finkel, you represent the candidate here?
That's correct, Aaron Turner.
Thank you. Okay, Mr. Erdman, this is your Rule 20 motion, so if you could proceed.
What we have here is the hearing officer's out-of-hand rejection of an expert witness that appeared before the hearing officer and testified as to handwriting that appeared on the certificate of deletion. The hearing officer had, prior to the evidentiary hearing, noted, what is there to say? If the man said he wrote it, then he wrote it. We then put forth our witness list and disclosed our expert and showed up with our expert. She did her homework, she did her evaluations, and I'd like to hand out the exhibit from the hearing. The handwriting expert performed her review of all of the sheets that were initialed by the candidate for his certificate of deletion. They're listed on the certificate of deletion, and they appear within the petitions with the letters A and T placed next to them. The hearing officer reviewed all of these. The handwriting expert reviewed all of these. The hearing officer made note of the fact that she didn't have a list of what she reviewed. Well, she did have a list of what she reviewed. It's a certificate of deletion. She went through and she reviewed every single line that had been crossed out and an AT placed next to it. The sheets in question have initials placed sometimes to the left, sometimes to the right, and as you can see by the exemplars presented by the handwriting expert, clearly in different hands. The candidate injected into the evidentiary hearing what was basically a doubt hearing to try and discredit the handwriting expert. He asked for statistical evidence, as if that's what would be presented at a hearing when an expert is testifying as to their evaluation of these specific exemplars. If you look at the exemplars, they're clearly from sheet 63, 66, 75, 99 on the first page. If you look at the second sheet, which the handwriting expert has identified as writer number 2, there's clear differences, and the handwriting expert testified as to those differences. Whether what she called the design of the letters. She clearly indicated what the differences were between writer number 1 and writer number 2. whether it was downstrokes, upstrokes, lifting of the pen, placing the pen back on the paper, etc. If you look at writer number 3, which is the third sheet, which are exemplars from sheet 20, 85, 90, and 92, she established again that this was, once again, a third hand placing these initials onto the petition sheets. Look at writer number 4, the fourth sheet. Once again, we have distinct differences in the designs of the letters and how they were written. The handwriting expert again testified to how a letter is designed, again, downstrokes, upstrokes, lifting of the pen, the dragging of the pen across. And then you can look at writer number 5, which I struggle to see any resemblance between writer number 5 and any of the other 4 sheets. The handwriting expert testified that it was probable that there were 5 different hands on these petition sheets, and highly probable that there were at least 2. The candidate made note that we never identified one of these as Mr. Turner's handwriting. It misses the point. All we have to do is identify that there's more than one. The statute clearly states that 2 people who can strike a signature are either the candidate or the circulator. In this case, it was the sworn testimony of the candidate that he was the only one who did it, and he did everyone. He relied on being tired, sitting in a recliner at his desk in his office, evidently has a reclining chair, and that he uses electronic devices and doesn't write much anymore. The candidate in his opposition brief made note of the fact that there's nowhere else that people have to put initials on things the way they do here. It happens all the time. People put their initials on documents every day.
Okay. I'm sorry. Okay. Go ahead.
Okay. The hearing officer, for no other reason than to say the candidate said he did it, so he did it, to then use that as a substitution for the expert testimony of the handwriting expert that's been employed by this board, it's ridiculous. It goes beyond what is shown by the evidence placed before the hearing officer and placed before the board.
Thank you. Mr. Finkel?
Thank you. The short version, this is a question of fact, and the objectors failed in their burden of proof. Going into the details, this was simply a weighing of the evidence, and it was a unique situation because it is something of a machine-type repetitive process. Somebody is writing, and I've tried this, and if your honors wish to try that, it is not easy to write your initials down a line on 1 page, let alone 2, 4, 8, 10 pages. Your hand reacts, and I think Ms. Marsh recognized that in the case Deputy versus Lehman Brothers, Inc. Ms. Marsh testified, this is from the decision that I provided to the hearing examiner at the evidentiary hearing. She said, a person always they have what we call variations. When a person signs their name, they never sign their name exactly the same way because a person is not a machine. And that's what was expected of the candidate here, a machine-type repetitive process. And he came in and he reviewed the 25 sheets, the 20 sheets that Ms. Marsh provided in her exemplar. And this is a demonstrative exhibit, which is 3rd or 4th generation page. This was through paper. It was a scanned copy that she printed on paper. She put it on her photocopier. She blew it up 300%. She cut that out, taped it onto another piece of paper, and then it became this demonstrative. So there's inherent errors, pixelations that come into this. The candidate reviewed the original petition sheets and said, yeah, no, I did that. That's my initials. I wrote those when I was going through to strike it out because I wanted to put in the best sheets I could. I knew there was a maximum I had to strike out the sheets that some of my circulators, you know, either were more ambitious, they got voters who were not in the district, perhaps something didn't match up, the signature didn't match. They had teams going through at the board. They struck out the sheets, the signatures on the sheets that were not matching. Certification of deletions were included.
What was the particular circumstances that the candidate testified to when he was doing this?
Well, it was after a long day of petitioning. He was under tremendous pressure. He was starting early in the morning. He was out getting more signatures, and then at the end of the day, at some point at 8, 9 o'clock, he'd come in and he would go through the sheets that would, his team had the copies at the board. They were reviewing the signatures. They'd put back similar to appendix recap sheets where they would identify the problems. He would go through with a ruler, line out, line out, line out, line out, right. That's his process that he testified to. It would be at his office at the end of the day during the week before petition filings.
And he did it all of these, he did it at one time?
No, he did them over about 5 days. I think he said it was 5 or so approximately. I don't have the transcript, but it was over a period of days, and it was directly that week before the first day for filing. So it's, and again, this is a weighing of the evidence. I think as was noted earlier, forensic document analysis is not 100% science. It's not a formula that you could put a number into and come up with an answer. Okay, is your number above or below the requirement? That's not the way this works. And Ms. Marsh was very careful when she was testifying. What she noted was how somebody wrote the letter, the sequence of the writing of the letter. Now, she had an ability to look at other exemplars from Mr. Turner. She had his statement of candidacy with his signature on it. She had a loyalty oath with his signature on it. She also had his signature and name printed and signed on as a circulator. She decided not to compare those exemplars. She looked at simply the ATs that were written on the side of the page. And, you know, a handwriting expert is a bit of evidence that is put together with all of the other evidence, and it was properly considered by this hearing examiner. I cited the decision from where the board's expert, Mr. Hayes, was offered on a case competing directly against Ms. Marsh. And one said the light was green, the other said it was red. You know, one said it was a forgery, the other said it was not a forgery. And two eminent handwriting experts came up with opposite conclusions. It is certainly possible, because it's not 100% proven science in the sense that it's not a mathematical type. It is an opinion. It is subjective. And I believe the hearing examiner properly weighed the evidence in this matter. I would ask that the Rule 20 be denied and that the recommendation of the hearing examiner be adopted.
Okay, thank you. Mr. Erdman?
As noted by counsel in the hearing in the first case that we heard today, that the handwriting experts never claimed to be 100% certain. That they give their opinion based on their experience, based on their knowledge, and consistent with her experience and her professionalism, Ms. Marsh admits to not being 100% positive all the time. It's a subjective evaluation of what was placed before her. For her to assert anything other than that would absolutely diminish her objectivity and her value as a handwriting expert. Now, she didn't look at the cursive signature of Aaron Turner on other documents, because that isn't what the allegation was. The allegation was that the initials on these sheets were made by more than one hand, which would mean that the candidate and neither the candidate nor the circulator placed them on that and would invalidate that certificate. The evidence placed before the hearing officer, the testimony of the handwriting expert placed before the hearing officer, this exhibit placed before the board clearly shows multiple hands signing these petitions. A right-hand person wouldn't go back and forth from one side of the sheet to the other. A left-handed person wouldn't go back and forth from the right to the left hand side of the sheet. These were formed by different hands. The testimony of a handwriting expert with 40 years of experience and exemplars placed before the hearing officer are sufficient evidence to prove that. And the hearing officer ignored that evidence. And those of you with experience in fraud know that you evaluate what's placed before you. And all of these initials are placed before you. And not only do you have an expert witness, you have your own life experience and common sense to tell you that these 5 were placed by different hands. And all we needed to prove is that at least 2 placed them on there.
Thank you.
Just a question for counsel for the candidate, just to clear up the record on this. How many total signatures were submitted, including the ones that were deleted? Approximately.
It would have been over 1,500.
Okay.
The first 1,500 or so, or there were 165 sheets that had strikeouts on them. I have the
I believe it was about 4,000.
here.
Let me do, okay, go
It
ahead.
was, right, so the board only considered the first 1,500,
Okay. The minimum number required was,
500,
and the maximum was?
1,500.
Okay. And what happens to signatures over the maximum?
They aren't counted by the board's process.
Okay, so in this case, the deleted signatures, it's necessary to delete those signatures
That's
so
right.
that, to use an expression, the good signatures are counted and not the deleted ones being in that first 15.
Precisely, yeah,
Okay.
precisely.
I just wanted to clear that up. for the
Okay.
record. Thank you.
Okay. Mr. Lask?
Quickly, the objector contends that the candidate signed the certificate of deletion when he knew it not to be true. He made a certification that was untrue. The candidate appeared before the board and testified under oath as to something that was not true. That calls into question not only the certificate of deletion, but his statement of candidacy in every petition sheet that he circulated and signed. So, thank you.
Okay, thank you. Mr. Lask, do you have any comments?
No, I would just say, no, we don't impute the initials to the statement of candidacy form. There's no evidence in terms of which signature on the statement of candidacy form. The hearing officer was there to take the testimony of the candidate, and I was not. The hearing officer weighed the evidence. The hearing officer is looking at deletion sheets. I believe that the hearing officer would have found that this is far from fraud, there's nothing being hidden. And so the hearing officer clearly found credibility in the testimony of the candidate and believed that the testimony was more reliable than the expert witness's signature analysis of nothing other than photocopies. She didn't even come to the board office to look at the original petitions. The record indicates that she used photocopies of just 2 initials. I wasn't there to hear the testimony of the candidate, but the hearing officer was.
Yeah, and, you know, there are many, many times in many, many different cases where we have competing competing experts. And invariably, in those situations, you have to credit one over the other. In this situation, I think, you know, after reading the hearing officer's report and your arguments, I do think that the hearing officer had discretion to take into account all the evidence, including the experts, and make a well-reasoned and informed decision, and I think that is what he did. Therefore, is there a motion to deny the Rule 20 motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motion is denied, and now we will turn to the final decision in this matter in the case of Ida B. Walker and Anita Archibald versus Aaron Turner, 20 EB RGA 009. Is there a motion to overrule the objections and adopt the hearing officer's report?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes and the candidate's name will appear on the ballot.
Madam Chair, I have a written decision to memorialize the board's action today. As a reminder to the parties, under section 10-10.1 of the election code, this now starts the 5-day clock for judicial review. They can wait a few minutes to get a copy of the decision served on them in this hearing, or if they don't wait, it will be served by regular mail. Madam Chair, I'd also like to request a brief recess our court reporting of our office.
Oh.
Because the hearing is constantly.
Well, let me, if we're taking a short recess, should we just take a little break for lunch, and anyway, we have to review, each of us individually have to review, some, yeah. 1:30? Is that too short?
Yeah. Okay.
Is that,
That's fine. So moved.
okay, we'll, be back at 1:30.
Thank you.
We are back on the record, and the next case for Rule 20 hearing, in our Rule 20 hearings, is 20 EB WC-001 Lauren Weber versus Jane Ramirez. Can you please state your appearances for the record?
Pericles Abbasi, first name Pericles, last name Abbasi, for the candidate and Rule 20 movement, J. Ramirez.
And I'm Lori Weber, W-E-B-E-R, and I am the objector.
This is the candidate for Rule 20 motion. Okay. Mr. Abbasi, would you like to start?
Yes, Madam Chairwoman. So on the Rule 20 motion, the candidate raises two issues. The first is the issue that we raised, or that the candidate raised in his Rule 5 motion to strike, as well as his Rule 8 motion, and that's that the objectors, what was attempted to be an out-of-district allegation, did not fully state the nature of the objection as required by the election code, and did not fully apprise the candidate of the nature of the objection as required by the precedent of this board. What the paragraph states, which is paragraph number 8 in the objector's petition, the verified objector's petition, is it says that the nomination papers contain petition sheets with the names of persons who reside outside of the first ward of the city of Chicago, as is set forth in the appendix recapitulation sheets attached and incorporated herein, under the heading column C, signer resides outside the outside ward, that's in quotes, in violation of Illinois law. The issue with this language is that it doesn't state that the basis of, or the evidence for determining that the signer is outside the district, which generally what it would say is that the address opposite the signature is outside the ward, and therefore it's an invalid signature. It just says the signer resides outside the ward. So what, according to the testimony from Mr. Carley, who testified about the procedures, they just took the this column, entered it as just the standard out of district in the joint petition checking software, and went through it. The problem is, just because the address that the person wrote is outside the ward, they never look to see, okay, is this signer actually outside the ward? For instance, if they're registered an address outside the ward, okay, that is evidence that they're outside.
What statutory authority are you citing for your proposition that it stated the wrong language?
I'm basically making it an argument under section 10.8 of the election code that it didn't fully state the nature of the objection, which is that, okay, the address given is outside the ward. But just saying the signer resides outside the ward, so technically by the language, if you have to basically prove that there's no address in the ward that this person is residing at in order to actually sustain this allegation. This would be similar to I think I gave the example of if the not registered allegation, instead of saying, if it just said the voter is not a registered voter, instead of saying they're not registered at the address given, or the address opposite their name, well then if you find them as a registered voter somewhere, then it should be overruled, because it's not saying what it should say to state fully the nature of the objection, which is that they're not registered at the address given opposite their signature. So that's the nature of that objection, that it just doesn't state fully that what it would need to in order to be a proper out-of-district objection. The other issue raised on Rule 20 is the calculation. The candidate is disputing the signature minimum of 1,032, and that's based on the language from the election code. So 10 ILCS 5/7-10I gives a signature requirement for ward committee person, stating if a candidate seeks to run for ward committee person, then the candidate's petition for nomination must contain no less than the number of signatures equal to 10% of the primary electors of his or her party or ward, but no more than 16% of those same electors. Now, while it does say 10%, the Seventh Circuit Federal Court of Appeals in 1986 in Yurtsin versus Board of Elections lowered that to 5% to be equalized with Suburban Township Committee men at the time, finding that it was required under the Equal Protection Clause because they're equivalent offices. Now, the question then is, so that section, subsection states, 10% of the primary electors of his or her party of the ward, or which is lowered to 5%. Then the question is, what's the number of primary electors of the ward? And 10 ILCS 5/7-10, which is a very long subsection of the election, or section of the election code, towards the bottom states, for wards or districts of political subdivisions, the number of primary electors shall be determined by taking the total vote cast for the candidate of that political party who received the highest number of votes in the ward or district at the last regular election at which an officer was regularly scheduled to be elected from that ward or district. So then the question is, what was the last regular election at which an officer was regularly scheduled to be elected from the ward? The obvious answer is that it was the February 2019 election when an alderman is elected from the ward. However, that's creates some problems because unlike when the law was written, mayors aren't running as Democrats and Republicans anymore, they're nonpartisan. So maybe under the strict definition of the law, it will be 1 through 51, but the candidate's not arguing for that. The board gets its number according to the 2020 election calendar from the November 6, 2018 election results. At that election, the Democrat who got the most votes out of the ward was Jesse White for Secretary of State. He got 20,634, and 5% of that comes to 1,032. The problem with using that number is that there was no officer regularly scheduled to be elected from that ward or district. And I'm arguing that from the ward means an officer just representing that ward, not a county-wide officer or statewide officer, a judicial officer that includes the whole ward, etc. And Mr. Lasker might have a different argument, but so then the question, so then if we're not going to use the 2019 aldermanic election, the last election when an officer was elected from the ward would be the February 2016 elections when the ward, first ward elected Democratic or Republican committee.
Mr. Boss, I have a question.
Yes, sir.
We're reading the hearing officer's recommendation, I also reference this argument and coming down to a determination on it. Was this brought up with the hearing officer, or the hearing officer?
It was not, but I'll point to Rule 20A, about Rule 20, where it says that any party disagreeing with the recommended findings of proposed decision of a hearing officer may move to have the Electoral Board review the hearing officer's recommendation and hear additional argument from the parties. This is an additional argument. I'm not bringing in new evidence per D. I would say that basically Rule
evidence of prior election results.
It's public record.
Yeah.
This is just a new.
Came to me recently.
Yeah.
It's in the Rule 20 motion.
It is true.
Yeah. All right.
That's correct. It was not brought before the hearing officer.
Well, for the sake of, I would appreciate it, well, I understand, we understand your argument about the numbers, because it has been brought up before
Yes.
in other matters, so
Right.
I understand that, but if you could just move forward, I'd appreciate it, just wrap up this particular argument.
So yeah, well, basically, that's, if we use the February 16 number, when the committee were elected, Susana Mendoza received the most votes. 5% of her number would be 599. The candidate received more than that. And I also pointed out that in 2012, the board used the candidate's suggested, or the candidate's, what the candidate believes is the correct calculation, and the county clerk also, in the 2018 committeeman races, township committeeman races, used that. And because of that, because the candidate's over 599, he's over what the minimum should be.
Okay. Do you have any other arguments?
No, ma'am.
Okay. Ms. Weber?
Yeah, so I obviously am not going to address anything about the numbers because that has absolutely nothing to do with the findings of the hearing officer. In relation to the
Can you
findings.
pull a little closer to me?
Yep. In relation to the hearing officer's findings, the hearing officer stated that to be a qualified voter, one must be registered to vote, and a person who signs a nominating petition must be registered to vote at the residence address set forth on the nominating petition. And that is exactly what occurred on the nominating petitions of J. Ramirez. The only objection that I needed to make for said persons was that they did not reside in the ward, which was indicated based on page and line numbers on each of the appendix recapitulation sheets. They were found to reside outside of the ward. Additionally, I went through this morning because he had made arguments during his Rule 8 hearing that the people could have a second residence and they still could be registered in the ward. They could be homeless, something of this nature, and I went through about 130 of them this morning, and they were all registered at the addresses that they had stated on their petition pages. So they were not simply, having a second residence, but they were still registered within the first ward.
Mm-hmm.
So based on the fact that, they don't reside in the ward, they should not count as signatures towards his petitions, and so he would remain under the minimum.
Thank you. I could just have 1 second. Okay, thank you for your arguments. After having reviewed your oral arguments and written arguments, I would move to deny the Rule 20 motion. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes and the Rule 20 motion is denied. We will deal with the final decision later on, not at this time. Okay?
Okay.
Okay.
Thank you.
Thank you. The next case is 20 EBWC-003, Lauren Weber versus Daniel Espada, candidate for Ward Committeeman, First Ward Democratic.
Madam Chair, the attorney, Frank Avila, representing Lauren Weber, the objector, was here earlier today, informed me at the break that he has a court call across the street, and he'll be back as soon as he can.
Okay.
So if we could pass this.
Okay. The next matter is 20 EBWC-0, well, Yeah, but we could do 007.
We're all here, we do that. Oh, good, we are.
Okay. The next case, we will recall 20 EBWC-007, Quintella Benson and Ava Thomas versus Anthony A. Beal. Thank you for your patience in this. Each of us have individually reviewed documents, and my suggestion is that we remand it back to the expert, handwriting expert, so she can review the affidavits in addition to the documents she initially reviewed. Is there anyone else who would like to comment on that? And then we would get it back for...
I think we do need the additional evidence, additional report from the handwriting expert as to all the signatures.
Mhm.
Yeah, I concur. I believe that looking at them, raising enough questions for me, I'd rather have the eyes of the expert who evaluated the initial petition, initial objections, would evaluate the additional evidence and come up with a ruling, and that would give me confidence in the outcome.
And then, of course, that's only part of it, because then we would have to analyze any findings of the expert in light of evidentiary rules and of this board. So, is there a motion to remand this matter to the expert, handwriting expert?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
And that's fine, and we will do that very, very quickly and bring it back here so that we can finally dispose of this matter.
Excuse me. I would like to propose that we'll get a report from the hearing, the handwriting expert. We'll serve that on the parties along with notices to when we can come back and continue this hearing.
Yes.
I would just like to ask, are there any specific dates that you think you might come back? I have a full trial in a non-election law matter a week from this coming Thursday.
Beginning Thursday?
A week from this coming
Next
Thursday.
week,
So,
I imagine we'll be back. I would like to say by Friday.
I would like to say this week. Yes.
If not Monday of next week.
Okay?
thank you.
Thank you.
Perfect.
Okay. The next matter is 20 EBWC-014 Marta Aviles versus Angie Gonzalez Rodriguez, candidate for Ward Committee Person, 26th Ward, Democratic. And if you could just provide us with their appearances.
Good morning, good afternoon. Andrew Finko for the candidate, Angie Gonzalez Rodriguez.
Good afternoon, Thomas Giaconetti on behalf of the objector, Marta Aviles.
Okay. And this is the candidate's Rule 20 motion. So, Mr. Finko, would you like to proceed?
Yes, thank you. The candidate herein submitted 935 signatures. After the records exam, 663 were determined to be valid. That's about a 71% validity rate. The Rule 6 report showed 23 signatures below the minimum. At the evidentiary hearing, we found out that the candidate's opponent is the competing candidate, and he submitted 1,760 signatures, of which 830 were valid, which is about a 47% validity rate. So these are the two candidates that are basically looking to compete against each other at the coming election. The hearing examiner went through various affidavits and evidence that was submitted. The candidate herein put in 41 affidavits. And the affidavits that were submitted were not the conclusions that simply say, I signed sheet number whatever and line number whatever. They were more detailed, and they provided specific information that said, I've reviewed the petition sheet from the candidate, which is the sheet and line number, and it's attached. And the attached sheet is important because then it identifies what it was that that voter looked at rather than some unknown sheet that some unknown operative or whoever might have shown somebody. This was a very straightforward campaign, very direct. When they showed the candidate's petition, they have it attached to the affidavit. The voter was able to add in some additional information to those affidavits. And those affidavits included, information and comments sometimes to say, what happened and why sometimes the signature may be different. The affidavits from the candidate also had exemplars that said, well, sometimes I sign my name one way, sometimes the other way. And so there was 41 of those that were submitted. And through the process of argument only, argument of very capable counsel, the hearing officer allowed 17 of the 41 affidavits to rehabilitate those voters' signatures, the signatures that were found on the Rule 6 records exam to not match what's on the voter registration record. So it's two exemplars that were being compared. The affidavit provided additional exemplars and an affirmation that I reviewed as a voter, reviewed the petition sheet that has my name on it, and yeah, that's my signature. I wrote that signature on that sheet. They offered additional information. So there were additional registration records that were also offered, and there were 11 registrations that were attempted to be rehabilitated. The hearing officer recommended that 5 of the registrations be rehabilitated. So that was one less than the minimum required for this office. The hearing officer's report does not address 2 additional rehabilitations that we attempted through walk sheets. Now, the walk sheets were from March 2019, and they showed the name and address of the voter at the address that was written on the petition sheet. So that was the candidate's case. The objector then offers the affidavit of Awilda Reyes. Now, the affidavit of Awilda Reyes did not attach the petition sheet that was reviewed. It was a one-pager, and it said, it was typed up ahead of time. Objector's notary came in and said, I picked up the affidavit, I brought it over with a volunteer for Alderman Maldonado, and they showed the affidavit to Awilda and she signed it. And then he claimed he notarized it there. Well, we had tried to meet with Awilda ahead of time, but that didn't work out. We did get an affidavit, and I know it's an exception here. It's an unusual situation. We are offering an affidavit from Awilda Reyes with the Rule 20. And that's attached as, I believe it's Exhibit F, as in Friday, which includes...
Madam Chair, can I interpose an objection at this point in time? That would be a standing one, and then the board can decide about whether it's going to address that proposed exhibit.
Sorry, But
Just to be clear, Mr. Giaconetti, your objection is that this was not presented to the hearing officer?
Right.
Absolutely not. It apparently was obtained several days after the hearing. It is now being submitted as after acquired evidence, and we believe that this is not within the letter and spirit of Rule 20. The proofs were closed. The case was done on Sunday, January 12th. So I'd like to interpose an objection at this point. I understand the board will determine whether or not this is appropriate, but before we clutter the record with argument, I thought I should speak up.
Thank you.
So the affidavit is offered, and I understand, Mr. Giaconetti's point technically, but if we're going for the real truth of what happened in this process, the affidavit illuminates what was discussed at the hearing. So at the evidentiary hearing, the candidate testified that she in fact was the circulator of Awilda Reyes's petition sheet. And it's sheet 3, and Awilda signed at line 8. So she says, yeah, I'm the circulator. I remembered Awilda specifically, and I remember going to her, her house, her address, because I went there when I was running for alderwoman of the same ward, the previous election, and Awilda was eager to sign my petition. She signed it. The same person that signed my petition sheet for alderwoman now signed my petition sheet for committee person, and that became sheet number 3. So we have competing facts, and I think as a matter of the burden of proof, the objector herein failed as a matter of law based on the hearing only, not considering the after acquired affidavit of Awilda. The objector failed in the burden of proof. And the burden of proof is in Rule 8, and it says fraud has to be proven by clear and convincing evidence. What the objector is saying here through the objector's affidavit procured by a Maldonado volunteer was that there was some nefarious forgery. Someone other than Awilda wrote Awilda's name on that petition sheet. Now, I think it's competing evidence at most that negates, because Awilda's affidavit says, I did not sign Angie's petition sheet, but we don't know what was shown to Awilda. And clearly, Angie would testify, and she did testify at the hearing, that Awilda, who somebody she knows personally from the community, was the person, the voter who actually signed her own petition sheet. So, Adam, as a matter of law, I think Awilda Reyes's signature, and it's important to note, very important, there was an objection lodged to Awilda Reyes's signature in the Rule 6 records exam, and it was overruled. The the handwriting expert for the board looked at sheet 3, line 8, Awilda Reyes, and affirmed that overrule. So based on the handwriting expert's report and the final detail report, Awilda Reyes did in fact sign the candidate's petition sheet. So I would ask that the Awilda Reyes signature be added back, because that was, I think, an error for the hearing examiner to take this affidavit of Awilda Reyes and negate, first of all, the affidavit of the candidate at the bottom of her page that she circulated, the circulator's affidavit. That affidavit was also used to negate her sworn testimony at the hearing, which clarified and provided additional factual detail. And it was also used to negate the board's handwriting expert, who said in the final detail report, yes, that is Awilda Reyes's actual signature on that petition sheet. So that's one that I believe should be reversed. There are a couple of other, I think, more obvious or same as obvious level, and that's the registration records, and that would be, the registration records were submitted for, let's see, and this is all set out in the Rule 20. There are a couple of candidates that are being, sorry, let me strike that, a couple of voters that are being prejudiced simply because they got married. They got married and their name changed. And I think the Sumlin case and then the cases that I cited confirm that on election day anybody can come in and vote as long as you're in the precinct, regardless of your name change. And if they can come in and vote, they should certainly be able to sign on a petition sheet. The Sumlin case exemplified that. If the voter is registered at the address, they should be allowed to sign the petition, and the signature should have been rehabilitated for, this is Ebony Carlton Murphy. She's been registered at the address that she wrote since 2015. That's sheet 52, line 3. Similarly, Rosemary Gordon Henry. There's voter registration records for her, confirming that she's been registered at her address that she wrote since 1996. And when she did register, she was registered under her maiden name, and then since then she has got married. And there is the sheet 53, line 8 should similarly be rehabilitated because they are registered at that address. And as was discussed in the prior case, section 7-10 states that it's the voter's signature that counts. The voter's signature is what's important, and then to the right of it shall be written the residence address. No evidence was offered by the objector to dispute the residence address. There was nothing offered other than argument of counsel and the affidavit of Awilda Reyes at the hearing. Oh, and then the testimony of the notary for the Reyes affidavit. The other two, I think, very apparent ones are sheet 92, line 3. Voter Lucerito Moroy was registered at the address when the petition was signed. And sheet 28, line 2, Liz Manjaras, M-A-N-J-A-R-A-S, was registered at her address per the petition sheet, as when she was signed. Candidate offered voter histories for each of these voters, which reflected a later address change. So after the petition was signed, they changed their address, and that subsequent address is what was used in the Rule 6 records exam. But when they signed the petition is the important part. That's when the circulator's oath was sworn, the affidavit is signed by the circulator saying, well, when they signed, they were registered at that address. I would ask that those, at a minimum, those be reviewed and added back to the candidate's total. There are a number of others. So the case that I cited is let's look at this on the whole perspective. Let's give the people what they want, a real election between two candidates rather than one name on a ballot. And the case that I'm referring to it's in the, I have quoted it in the Rule 20. It's Galvin versus Martinez, OAEBWC 30. And the Electoral Board has the discretion within its authority to review these affidavits and to say, well, let me look at these affidavits as a whole. And let's take a look at what the competing interests are here, and let's keep in mind, as was pronounced in Velasquez versus Solis, that statutes involving disqualification should be construed liberally in favor of eligibility, and every doubt must be resolved in favor of eligibility. So there are a lot of affidavits where, for one reason or another, somebody printed their name on a petition sheet, or somebody's printed name didn't look the same in the hearing examiner's opinion to the registration record from whatever time. We don't know exactly what the date is on the registration record. Sometimes it shows up on when the image is clipped, the signature clip is created. Sometimes it shows up, sometimes it does not. So there are many reasons why a signature changes over time. And it could be as simple as maybe it didn't change, but maybe I was in a hurry and signing on a clipboard as I was carrying my kid in one hand and trying to walk to the car, and get myself out of wherever I was. That's a big factor, urgency in signing on a clipboard. So I would ask the board to consider all of the affidavits as a whole. 41 were submitted. That's no small undertaking from a candidate who already had a 70% validity rate on her signatures that she turned in initially.
Thank you. Mr. Giaconetti?
Thank you. I would like to divide my review of the situation into two categories. The first being the nature of the Rule 20 and what the candidate is arguing and attempting to do, and then go through some of the particulars. I will not go through every single signature or whatever, because I think that's why you have a hearing examiner and you have the transcript and you're assisted by able counsel. But let me start with what this Rule 20 is. It's 217 pages, of which 150 pages are part of the record below the hearing with the hearing officer. 150 some pages cover exhibits A, B, and C. The hearing officer reviewed those documents and heard the testimony and heard the evidence. The balance of the Rule 20 motion, outside of the 15 or so pages which argue their position, which is perfectly appropriate, we have three cases that are attached that are Electoral Board decision authority, and I want to address each one of those in my second half of my remarks. And then we have exhibits E and F, which I think are totally improper. 9 pages of later identified evidence. And I'll jump ahead on this point because I'm sure I'll forget it, I've written it down 3 times. The parties exchanged information and affidavits on Friday. The hearing was set for Sunday. Saturday intervenes. there would have been no way that I would have been legitimately able to object to their producing of Ms. Reyes at the actual hearing in rebuttal. Clearly, if they wanted to submit an affidavit or get information from her on Saturday, that could have been obtained, presented to me, presented to the hearing officer with a request that the exchange of evidence date of Friday be extended to cover this. There was no surprise. They had her affidavit on Friday. We went to hearing on Sunday. They procured an affidavit on the 15th, 3 days later. In addition, if you look to the documents that are filed, we not only have that affidavit, we have a second one, an affidavit on top of an affidavit saying, I really did sign that other affidavit 3 days later. And that's not dated, so we don't know when that was procured. We have 2 photographs that weren't in the record, and we have a driver's license of some other potential signer or circulator. I don't know who this is. This is all submitted after. This violates the letter and the spirit of Rule 20. These cases are hard. We all know it. We're under tremendous time constraints. We have to try to marshal our evidence as quickly as we can, get the witnesses in, be respectful of the process, prepare a ballot, care about military and absentee voting and everything else. These are weighty, important constitutional rights at stake out there. And there has to be a beginning, a middle, and an end. And the end was Sunday, January 12th. Now, when you look at what's being presented, let's talk for a minute about the hearing. I don't remember that I've ever had the pleasure of having an extended hearing before this particular hearing officer before. But I will tell you that we convened and spent 7.5 hours together on a Sunday. And I found her to be careful and calm and thoughtful. She was clear, verbal, cogent, insightful. She was precise in her rulings and explanations at the time, and decisive and patient beyond all measure. She was even-handed. She called the balls and strikes. Those of you that know me know I love baseball analogy. That's what umpires do. They call balls and strikes. I remember being at a playoff game with the White Sox in Seattle many years ago, and I had a clear line on that play at second base, and I said the guy was safe. You know, and our guy was safe, and the umpire called him out. That's the way it goes. That's what hearing officers do. She weighed the evidence. She was very even-handed. And she brought an experienced expertise to this. And I think if you're going to find in the transcript, although her report is a bit truncated because it says change or no change, if you read the transcript, you are going to hear her colloquy, her discussion, and her walking through the decision process very clearly. And I have to tell you, there were points where she ruled against me, and she was right. I tried to rehabilitate 3 duplicates. You heard a duplicate argument earlier today. And she pointed out to me that look at the originals. The originals were clearer. She pointed out to me that what appeared to be stray marks on the photocopy were actually monikers of junior or senior. And I lost those, and I was right to lose them. So I think she brought credit upon herself and the board in the process. I think that this board should give some deference to the people who hear the evidence and have to weigh the records, weigh the testimony. And so what does the candidate really want here? They want to redo. They want to hit the restart, refresh button and start from scratch. Every time we lost, the hearing officer made a mistake. Reverse everything that didn't go their way. Reweigh the evidence, reweigh the equities. Retry the case de novo. Rebalance the credibility of the witnesses. And on that point, let's talk about just this process when it comes to the witness relative to Ms. Reyes. That witness was very clear, cogent, precise, detailed, identified who was in the house, what the house looked like, where he met her, how he spoke to her, that they showed her her prior signature. They asked her to identify and to verify whether it was her signature. It was not. She said that it was not. The witness was very conclusive in his explanation of the process of authentication, that it was notarized in his presence, the identification that he got from her. He was unambiguous. And originally, so that you should know, the hearing officer originally ruled against me on this and said, I'm not going to overturn this just on the affidavit. I want to hear the testimony of the notary, because the notary was disclosed on our list. But the hearing had gone so long that we had dismissed our witnesses subject to recall. And we obtained the notary. We waited a half an hour, did other things. The notary came and testified. and the testimony is in the record. I don't think anybody reading that testimony has any reason to doubt the truthfulness, forthrightness, veracity of that witness's testimony. Clearly shouldn't be impugned by an after-acquired affidavit 3 days later, in which we don't know who formulated the handwriting that's on that affidavit that makes certain accusations. And because we knew that it had turned out that this affidavit was very important, we held our witness at the call of the hearing officer and potential recall of our side. The hearing officer recalled that witness back at least once, maybe twice. I can't remember if she called him back twice and not the third time, or once and not the second time. But the point was, when she wanted clarification from that witness, she called him back, asked him questions. So the issues were totally vetted. So when we look at the timeline and we look at the proofs and what was submitted, this was a hard-fought case. They have to be when they come this close. And counsel ably represented his client, and we did the best we can for our client. But at the end of the day, close isn't good enough. The Illinois Supreme Court has said so. You either have the minimum or you don't. Now, the second part, let me turn to the motion, specifically in some of the details. What did the hearing examiner do in this case? She followed the rules of the board. Rule number 1, together with rule number 2, which delegates most of your Rule 1 authority except final decision-making to the hearing officer, requires that the hearing officer develop a clear and capable, complete record. Also, B5, rule on relevant evidence. B11, consider affidavits. B12, make determinations of genuineness of signatures by comparison. B15, prepare the record. She has the same powers as you to accept final decision, which is yours. And under Rule 2A, all those powers I enumerated. 2B, give a report. C, certify the record. D, determine validity of signatures. And how did she do the last part, D? In the 3-step process that this board has established forever. And I only have to quote Bright versus Belair to you from 080 BWC 042, and then of course Fitchy versus Romanelli, 08 WC 037, Zaragoza versus Vasquez, 16 EBRGA 03, paragraphs 26 to 39, Lopez versus INIGUEZ, 16 EBWC 021, paragraphs 21 to 34. In all of those cases, this board has established the 3-step process that the hearing officer did here, which you will see when you read the transcript. Compare the voter's signature in the original registration or the signature clip provided on the summary, or the summary of decisions of the records exam. Compare that to the petition. Compare that to the more recent signings of affidavits. It's exactly what she did, okay? And those 3 last cases all made their way to an appellate court on other issues. We don't have to worry about the appellate court decisions in those because it's your decisions under Caldwell and Briscoe, your precedents that you will follow. And so this process is exactly what was done. And she did it very judiciously. We won some, we lost some. Counsel raises in his motion Lyles versus McGee. Lyles had to do with rehabilitation of printed names. It's one of those things that in 40 years of doing this is probably one of those cases I'm most proud of having been involved in. I represented Galen McGee. Nobody would take his case. He was running against a person who had a tremendous distinguished career, Senator Margaret Smith, 20 years in the Illinois Senate. Nobody would take his case. And I took his case. I don't remember how he came to me. But he impressed me as a young black professional. And the question there was, could you rehabilitate at the end of the day a printed name? We had a whole bunch of Rule 8 hearings, but now we came down to the printed name, and the predecessor to this board had ruled for 10 years as of Saltaris versus Kahn that you could not. And in that case, we won that case, and Lyles McGee and Galen McGee got his shot because this board said, yes, you can rehabilitate a print. And since then, hundreds of candidates have come before you and rehabilitated prints. Now, how do they do it? In the 3-step process that talking about here. So when counsel speaks of the affidavits that weren't accepted, or some people had printed their names, his exemplar presented 2 cursive, I believe, and 1 printed, okay? And the hearing officer had the registration record and had the petitions in front of her, all right? And our affidavit, by the way, has 3 cursive and 3 printed, all right? And this process has been in place now for 18 years, and it served ballot access well. Galen only got 6% of the vote, but he got his chance. Then we look at the case of Galvin. Council wants the board to look at Galvin and say, let's do our own analysis of these affidavits, or let's do a sampling of the affidavits. In Galvin, this board sent it back. Well, no, didn't send it back. Did that process partially, I believe, because the hearing examiner in that case found about 80% of the affidavits to be valid. There were 92, I think, and accepted 71 and didn't accept 19. That may have weighed in the balance. Here, the hearing examiner accepted 41%, okay? And looked at the data and looked at the handwriting and made determinations. I don't think that this is the sort of case where the board would be served by sampling. I think the board is better served by upholding the discretion of its hearing examiner, who spent 7.5 hours hearing all the testimony, looking at all the evidence. And then finally, Sumlin. What's missing here as opposed to Sumlin? Counsel points to 2 candidates, his Exhibit 42, Ebony Carlton Murphy. Ebony F. Carlton Murphy's registration record says, Ebony F. Carlton Murphy. She signed it one way, Ebony Murphy or Ebony Carlton. The hearing officer ruled in her favor. So that's gone. They won that one already. And why? Because it makes all the rational sense in the world. When I saw the registration record, she's got the F, she's got the Carlton, she's got the Murphy. You don't have to have everything when you sign, but that's clearly how she was registered. Not true with Rosemary Gordon Henry. Rosemary Gordon Henry has a certification from this board of her name as Rosemary Gordon. The poll sheet says Rosemary Gordon. 6-54 of the statute says if you choose to use a different name on election day, you can do so. And if this is truly a situation of a married woman, it could have happened. But counsel does not quote the second part of that statute, which says, and I quote, in the event the affidavit shall be treated by the election authority as authorization to cancel the registration under the former name, and the election authority shall register the voter under his or her current name. Your certification as of January 7th, 2020 does not show that current name, and we are no longer permitted to get the applications for ballot because of an appellate court decision. But the point is, the registration wasn't changed. The hearing officer looked at that and made a decision. It's not the I can't say it's the same one and the same person. Another one that was brought up was Exhibit 44, Sheet 92, Line 3, Lucerito Moroy. Here we have a poll sheet from March of 19, a certification from the board of her registration as of January 7, 2020 at 5537 South Francisco, clearly out of the district, okay? We have a notarization date of 12/1, a change of address alleged to be 11/26, and the hearing officer said that she didn't have enough evidence to support a change on that. Particularly, I would like you to look at that petition sheet and see what address is on that petition sheet. This is Sheet 92, Line 3. The address actually placed there was 1725 North Drake. It was crossed out. And someone, we don't know whom, put in 1624 North St. Louis. What we now know is she's registered at 5537 South Francisco. I don't want to belabor the hearing with going through every one of these.
Right, well, I wanted to,
Yes.
to just focus in on a couple, those that you just mentioned. Lucerito Monroy. You're correct that 1725 North Drake is, crossed out, and 1624 North St. Louis. So, did you say that they were within the district or outside?
1624 would be within,
Within the district.
which would be within the ward. I don't know about the other address. I was merely pointing out that there is a discrepancy on the document itself as to what the address was given by the voter.
Okay. And then, yes.
I just do want you to know that Barbara Goodman has reviewed this case very closely and can provide information to us.
Okay, Ms. Goodman, so I was especially interested about Lucerico Moroy.
The memo, we originally had determined that it was notarized on October 12th, it's notarized on December 1st. Having been notarized on December 1st and having the change of address on 11/26/2019, there's no way to determine if this person was registered at that address at the time they signed the petition.
And then with regards to Rosemary Gordon Henry, we're talking about a woman who, maybe due to marriage, had
Right, and as to this particular one, there was an affidavit that said that sometimes she uses Gordon, she uses Gordon Henry, that she did sign the petition, she did notice, she did review the petition and did acknowledge that she had signed the petition.
Okay.
And there is, we would point out, there is a case, Connor versus Holmes, 15 EB ALD 110, that would recognize that would be, in our opinion, a valid registration, valid signature.
It would be valid.
Mhm.
Okay. And we're going back to Mr. Moroy, Exhibit 44, would that be a valid signature?
There is no way to determine, based upon the evidence presented, whether this person was validly registered at the address shown in the petition at the time. And given that the notarization was December 1st, 2019, and the address change was 11/26/2019, I believe that the hearing examiner was correct in determining that there was not a sufficient basis to change that order.
She may have signed the signature of the petition before she changed her registration.
We're talking about Exhibit 44.
He may have, but the notarization date does not tell us exactly what date the person signed, it just tells us that they did not sign after that date.
Was there testimony as to when this petition sheet was circulated?
There was not, as far as I know.
Not on this.
So, as to Exhibit 44, Mr. Moroy, then if we know it was signed before the certification, right?
It was signed, all we know is that it was signed before the notarization date of December 1st,
Okay.
2019.
Or before, exactly.
Right, exactly.
And then if it was signed before and the address was changed before then, would it be considered to be a valid?
You have to, the address on the petition must be the address at which you were registered at the time you signed the petition.
Not the time you signed, not the time, or the date that it was notarized, the petition was notarized.
Correct.
Right.
Okay, but as to the date that it was signed,
We don't know.
we have no basis to say that it was signed, after
There was no
change
testimony.
registration.
Correct, there was no testimony provided.
I would ask that the board take note of the circulator's affidavit that does affirm that that voter was at that address as set forth above. That's what the circulator on every page attests to. The voter did not write the new address, 5537 South whatever, 5537 South Francisco. So if the voter had changed the address when this was signed, presumably the voter would have written the correct address. But instead, the voter wrote the address that he was at, the 1624 North St. Louis. So if you take, again, just the First Amendment concerns that nomination papers should be presumed valid, that this does show his address, that was a registered address up until November 26th. It's a few days afterwards it was notarized. So the inference, the logic to me would be that Lucerito had not yet changed the voter registration and when the petition was signed. And that at some point thereafter, when, and everybody knows you don't get notarizations the same day always, because notaries aren't always available. You, especially on a smaller campaign like this, where there's few people circulating, it's not a large organization. But it should be given, the benefit of the doubt should be given to the candidate on this one.
But there are assumptions that were just made in that statement. One is that the voters signed the address on St. Louis, and we don't know. We also know there's another address there on Drake. The second is a factual legal point, and that is the circulator's affidavit says, to the best of my knowledge and belief. So the knowledge and belief of the circulator is the only thing that's being attested to, not the fact of the time of signing. And I think counsel for the board are consistent with our view on this, and that is you can't establish as a matter of proof when the signature was placed on the petition.
But whose burden is that, Mr. Jack Kennedy? With you as the objector, all you've brought forth is a notarization date. Is that sufficient evidence to prove to the board that the signer actually signed after November 26th? Is that the date? Correct, yes. November 26th is the date of the registration change. So we know that she's got a proper registration as of November 26th at the address that's on the petition. The only evidence that the objectors brought forth is the notarization date. Is that sufficient evidence to overcome the presumption of validity on a petition signature that shows the correct address for where she's currently registered?
Well, actually, the objector's petition didn't bring up the date of notarization. We're speaking of it now because that's an issue that you brought up, all right? We said the signer was not registered at the address shown. The records examining clerk agreed. That was the ruling. That was the Rule 6 decision. That was what was appealed on Rule 8. Now we get to Rule 8, and it's a matter of burden shifting, okay? And so the defense that was put up by the candidate is the intuitive defense that was just made. So I can't argue against something that wasn't, alleged at the beginning. I can say, though, this, I believe, and that is the hearing officer's determination, weighing all the circumstances, the totality of the evidence, I believe is something to which this board can reasonably give deference.
I'd like to just take a few, just 1 minute.
There are two reasons to establish residency. One is to establish physical presence, and the second is the intent to remain in that place as a permanent home. He also pointed out Neely versus the Board of Election Commissioners for the City of Chicago. So Neely has nothing to do with my case. Neely case is about the candidate was residing physically in 2 locations. So therefore, they had to bring the voting record into play to determine which residency was more valid. I have lived at one address physically, and I pointed that I have established that through my evidence of having utility bills that I paid, communications from moving out of one district into the 27th district. And then I have also established an intent to remain there by continuously paying my bills there. I also want to draw your attention to page 23, because it all is reflected on page 23 of the objector's ruling, well, the objector's point, and also the recommendation of the hearing officer. So the last paragraph of the page, it states that in sum, by her own actions, this is line 55 of page 23, in sum, by her own actions, candidate put herself into a residency no man's land. She effectively and completely terminated her physical presence in the 35th district, so she ceased to be a resident for constitutional purposes relating to candidacy in that district. At that time, she manifestly commenced and maintained, notwithstanding an internal move, her physical presence in the 27th district, but her failure to vote in her new district left doubt by her intention to remain. There was no doubt because I continuously provided my utility bills and I physically maintained a presence at 97th Street address. She extinguished that doubt on July 20th, 2019, when she finally registered herself to vote in the 27th district. Thereby, she satisfied at least both of Meckesum's tests, physical presence and intention of presence. So they said I passed that test. In doing so, she established herself as a resident of the 27th district. Perfected residency came, however, too late to qualify her as a candidate for election in the 27th district in November 2020. He is suggesting because I changed my driver's license on during that time that is when I had perfected residency, when in fact the Illinois Constitution has nothing about perfected residency. It only states that you live in the 27th district, and I have presented substantial evidence that I live in the 27th district with an intent to stay. I also wanted to point out that this recommendation from the hearing officer has substantial amount of errors in it, stating that I live in one district and I do not. Just as with the first objection that was submitted. So there were errors in both the original objection and in the recommendation letter as well. So going back to my letter. So I felt the line of questioning was outside of the realm of the objection listed, because he went on and on to talk about my address. Third, the only evidence the objector, the lawyer, Mr. Casper, provided was my voting history, in which Mr. Morris questioned himself. Mr. Morris called Mr. Casper up, and they spent over 30 minutes poring over the only piece of evidence that they had, which was my voting record. It's confusing. He could not explain the information on it, and neither could his counsel when he went to them for advice on it. Therefore, if the hearing officer was questioning the objector's only evidence, how could they have met their burden of proof? Fourth, a candidate running for the state representative only needs 500 signatures and over 1,100 constituents in the 27th district signed their name to my petitions to be placed on the ballot, which was not objected to. Please let the voters decide who they want to elect on March 17, 2020 to be the next state representative of the 27th District. Therefore, I would like to ask the Board of Election Commissioners for the City of Chicago to not take the recommendation from Mr. Morris and rule in favor of my name, Marlo Barnett, being placed on the ballot as a candidate for the state representative of the 27th District.
Thank you. Thank you, Ms. Barnett. I appreciate you coming down here, despite working as a teacher, in order to let us know what your thoughts were regarding the hearing. And although at this time, legally, we really have no choice but to affirm the hearing officer's decision. What I would like to tell you is that I hope that, is this the first time you're running? You're engaged in this process?
It is.
Yeah. It's not easy, and it can get very complicated. I just hope that you continue your efforts to run, because it's clear that you're very, you do want to make a change and you're very committed. But unfortunately, at this time, we would have to sustain the objections in this case.
So are you saying that the
hearing
objector
the hearing officer's decision will stand, and we will issue our final decision. But I don't want to dissuade you from trying again. And I know this is a very complicated process.
Well, if I may ask, since I've been waiting here, and thank you for sharing the information, but I don't, as complicated as it is, I don't think that the objector met their burden of proof by only having a voting record as the evidence, as the sole evidence of my physical residency in the 27th District.
Madam Chair. Dr. Barnett, hello. I'm the attorney for the board. Back before I was in this position, in about the winter of 2006, leading into 2007 elections, I represented the objector against Dr. Neely, who was the candidate in that case that's been cited heavily in your case. So everything I'm hearing from you today is reminiscent to me to everything I heard from Dr. Neely back then, who was a lawyer, he was actually a dean of my law school. He had owned for 20 years or so a home. He owned it, and he was a lawyer and he practiced law out of his home. And he brought in a mountain of evidence, and he brought in witnesses to testify. I remember his neighbor from across the street saying, I see him out there every morning in his bathrobe getting his newspaper off the front porch while holding his cup of coffee. He definitely lived there for 15 or 20 years. I came in with 2 pieces of paper, his voting history, to show that although he wanted to run for office in that ward, he hid for years and years, and most importantly, during that residency period where he was required to be a resident of his ward, he was voting in a different ward. And the reason that that can undo all of your evidence on where you live, and believe me, everybody in this room today, we know where you rest your head at night. We know that you didn't lie to us in your nomination papers. There was a factual inaccuracy based on law in there, but you live where you say you live. But you have gone from the 27th district into the 32nd district and voted there. And in order to vote in a precinct, you have to be a lawful resident of that precinct. So for the record now shows that for 3 times after you moved out of the 32nd district and into the 27th, you still went back and voted in the 32nd, which only a resident, lawful resident of the 32nd district is allowed to do. So we have to take your word for it when you sign that application for ballot we're taking your signature and your word for that you're a resident of that district. You can't then come in today and tell us, no, I didn't mean that. Back when I voted those times there, which I could only have done if I was a lawful resident of that district, I didn't mean that. But we can't take that away. And that's why under operation of law, voting someplace, having a driver's license someplace, these are called benefits of lawful residency that only a lawful resident can have. And you can't have more than one lawful residence. You might own a winter home down in Florida, but you have to make a choice. Which of those is the one location where I'm going to have my driver's license, my voter registration, any other kind of thing that you're only allowed to have in the one place you're a lawful resident. And so that is why 2 pieces of paper have undone your entire candidacy, even though nobody here disputes that you now have a home, and in July of this past year, you finally acquired a lawful residence where your home is. Does that make it a little clearer?
There's nothing in the Illinois Constitution that states that the voting record is the evidence, the primary source of evidence that shows your residency.
That is correct. It does not say that in the Constitution.
And in Neely's case, he had 2 physical residences.
The hearing officer's wrong. His parents still lived in that other place, but that wasn't his home. He didn't
I've
live there.
only established 1 residency at a time. One.
So,
For-
Ms. Barnett, why didn't you change why did you vote?
My mother passed during that time, and so I was divorced. I had a lot going on then, and I was told to go back to the place, where I voted previously, and so that's what I did.
And that's the proper thing to do only within the 30 days before the election. If you move out of the district within the 30 days before the election, it's the only time you're allowed to do that. And you voted 3 different times.
And again, I'm trying to understand this. So the voting history, if the Illinois Constitution wanted voting to be the primary evidence, then it would explicitly state that where you vote is a requirement to run for office. It does not.
It's not stated in the Constitution.
Only
It is stated in the election law.
only the Neely case that has went forth has established that. It is not, even though the Neely case established that, it does not is not factual in the Illinois Constitution.
Okay, and Ms. Burnett, what you didn't hear that Mr. Lasker said, it's not in the Constitution, it's in the election code. So we have a statute in Illinois, which is the election code, and that governs.
So the election code states that where you vote at is the primary source of evidence.
The election code says that you have to be a lawful resident of the precinct in order to vote there.
Not voting, because this is my voting record that was used. A lawful resident.
Right. You had to have been a lawful resident of the 37th district
And
when you voted there.
Okay.
a lawful resident.
Yeah.
But it still does not say the word voting, where you voted from. And I think that this board and this whole Neely case continues to set a precedent and continues to disengage people like myself from wanting to run for office. Just because the Neely case, for whatever reason, I'm considering it was a high-stakes person, I'm being told that this Neely case was based on.
I don't know what you're really talking about.
Well, it should not set a precedent for if a person physically resides in that district. It should not set a precedent. Where I voted, I cannot go sleep at that ballot place. I cannot go eat there. I cannot do anything. I just voted there.
And that's the pivotal part. It's not just voted there. That's the pivotal part.
You swore to the state of Illinois that you were a lawful resident of that precinct, and then you voted. That's what you did. When you signed that ballot application, you said, I'm a lawful resident of this precinct, I'm allowed to vote.
Okay, but there are also other lawful pieces of information that can be used. I don't understand, just because this is the commissioners, the Board of Commissioners, and this is the institution where people, this board governs the act of people voting, that you would use that as the primary source of evidence.
Because the law requires us to.
Yeah, so when there is a published appellate court opinion, if it's binding on this board, then I don't see any distinction between the Neely case and Angus case.
And I think we have to move on because we have other matters to take
So
care
you're,
of.
one more question, you're saying that there's no distinct between my case and the Neely case?
That's correct.
So there, and then there's no distinct in the other one either, the Marcuson one to establish residency?
Well, you see,
Because my voting record was only been in account due to the Neely case.
with the Maxim case, are you aware that that involved Rahm Emanuel?
Exactly, that's the case I was talking
If
about.
if he had voted in Washington DC, he would not have become mayor because he would not have been eligible to run. Applying Maxim to Neely, you have to look at, well, where did Rahm Emanuel vote? He continued to vote in Chicago, which is the election district where he was running. Had he gone and voted in Washington, boom, end of it. He wouldn't have been able to run for mayor.
So based on the Marcuson's case, the number 2, still the required, what does the law, what does the code say about the second portion of that? Because the first part I met with establishing residency.
Physical
It was
presence.
the second part with the intent. And so you're saying that because I changed my driver's license on that day, that I became, it was quoted as a perfect residency.
Perfected means you accomplished it. It
Perfected.
doesn't mean it was perfect, it just means you accomplished
Okay,
it.
but that's not even, that perfected word is not even in the Illinois State Constitution.
No, that's
It
the
doesn't
hearing
have
officer
to be.
using fancy
Yeah.
words.
But we need to move on.
I'm just trying to get an understanding
I
of what,
understand.
can you tell me about the second
Well,
part
I
of the
think
Marcusons?
maybe after this, but we have other people
Well, I have to go
waiting
get my
here.
daughter afterwards.
Okay.
I would
just
like to
wanted
suggest, did you receive the email that I responded to you informing you that when you had sent the email saying you couldn't be here today, I responded to you and said I will read your letter to the commissioners. Did you get my email?
Yes.
Okay, so you know how to reach me. If you would like to reach out to me after this hearing, I can try to explain this in greater detail.
Okay, it will be no point after this, but, yes.
Well, there's next time. We'd like to see you try this again,
Right.
next time.
Is there a motion to sustain the objections? Second?
Second.
All those in favor?
Aye.
Motion passes, and the candidate's name will not appear on the ballot. I am going now, we have
Yeah,
a.
Dr. Barnett. We have a written final decision, Dr. Barnett, that we are going to have the commissioners sign. If you'd like to wait just a couple minutes, they can give you a copy of that today. If you don't wait, we'll put it in the mail to you today. And then either way, under section 10-10.1 of the election code, this means you now have 5 days from today to file a petition for judicial review if you seek to do so.
Okay, or I can choose to be a writing candidate, is that correct?
That is correct.
The board has to change the way it does its business.
I would say if that's your, just very briefly, if that's your intention, I would be in touch with Mr. Lasker sooner than later to do that, because there are some requirements with respect to that. We can't give advice, but we can advise you as to what, in a
The
broad
board,
sense.
the board is required to give you a copy of the write-in form should you want one.
Yep. So you should be in touch with them sooner than later.
We will now proceed with the rest of the hearing officers' reports and proposed final decisions. And what I'd like to do is I'd like to confirm the cases that we have already ruled on, which is on the agenda numbers 1, 2, 5, 6, 7, 8, and 10.
Madam Chair, I'm sorry to interrupt.
Let me just go through them. I'm just confirming which ones we've already,
May I?
yeah.
Okay.
Okay, we're back on the record, and although we did not receive a formal Rule 20 motion here, we're just going to call right now 20 EB RGA-012 Kimberly Williams versus Mark Lovelace, candidate for representative in the General Assembly, 26th Representative District, Democratic. Mr. Lovelace, you want to step up for a moment?
I'm going to assist Mr. Lovelace.
I'm
Will
sorry.
you get an appearance on file?
I will file an appearance.
Well,
I'm doing a pro bono,
okay.
I'll do a pro
Well-
bono.
Mr. Alvo, we're not going to accept an appearance. We're going to accept a statement from Mr. Lovelace. You haven't represented him throughout the case.
I have not represented throughout the case, no.
Okay.
But I can represent him at this level.
Please do have a seat, Mr. Lovelace.
Are you denying him counsel? I mean, I can write I could file an appearance in standard.
Mr. Lovelace, it appears that you sent an email to the Board of Elections on Monday, January 13th at 10:41 a.m. It does say you'd like to appear before the board. It does not claim to be a Rule 20 motion. The way that you appear in front of the board, there's two ways you appear in front of the board here today. One is by filing a Rule 20 motion, which also has to be accompanied by a proof of service. The record doesn't show any proof of service on the email that you sent. It also, the record does show you did not copy your opposing party on that email. So the board cannot and will not accept that as a Rule 20 motion. The second way you can address the board today is that these meetings are governed by the Open Meetings Act, which does allow for public comment. So I would suggest that we'd like to, the board will certainly hear what you have to say, but I think you need to fill out a public comment request form and say it there.
Okay, Mr. Lovelace, are you ready?
Now, Madam Chair, we're taking the agenda a little out of order because
We
public
have.
comment comes later. I would like to point out the Electoral Board rule on public comment.
Yes, and that is, would be right after the final decisions.
Now, we can take the agenda out of order. We don't need to make them wait longer. I think Mr. Lovelace has perhaps been here since 11 o'clock this morning.
Right.
But in terms of Rule 3 of the Electoral Board's Rules of Procedure, specifically Rule 3F, it states public comment is allowed only to the extent required by Section 2.06G of the Illinois Open Meetings Act, and only at designated times during open meetings of the Electoral Board. Except as otherwise stated herein, public comment shall be limited and governed by the public participation rules for the Board of Meetings of the Board of Election Commissioners of the City of Chicago, as adopted and amended. Not quoting from the rule, now I'll say that does include a 5-minute time limit. Back to reading the rule, what's more importantly here is that public comment shall not be considered as evidence, testimony, or argument in any case before the Electoral Board, and it shall have no impact on any decision rendered by the Electoral Board. Public comment may not be transcribed and may not be included in the official Electoral Board record, case file, or transcripts. So I just wanted to make that clear, given these unusual circumstances.
As a public citizen,
So what
Mr.
is
Lovelace?
he saying? So what is that? So what I'm in this, I'm making a request that the board not accept the recommendation.
Yeah, and as we stated, you did not abide by the rules, you didn't follow the rules. That would have been a Rule 20 hearing, what you've been hearing today.
Right.
and there's a certain amount of time by which you have to file a Rule 20
I did.
motion, but you have to serve it, your motion, on the other parties, on the objector. You did not do that, and that is one of the reasons why we cannot treat it as a Rule 20 motion. We're giving you, we're allowing you the opportunity to speak out of order. This is public comment. We're giving you that opportunity, but we cannot take it into account in terms of your case.
See, then what's the point?
Well, it's totally up to you, but there's certain specific rules that we have to follow, and as a result, we cannot take anything you say here relating to your case in support of it.
Okay, all right, I just want to say one thing too. I received the email, I received the notice electronically, and then I responded electronically back. So there was, you know, I didn't know that. I mean, how do you not? I didn't know that.
Well, we have written rules, and it's clearly spelled out there. I'm sorry, but, I mean, the objector is not here. The objector should have received notice so they could respond to any of your arguments and claims. And so that is one of the reasons why we have these rules.
Well, I've been communicating electronically. That's what I thought I should do. So that's what I did. That's what I was abiding by the rules.
The problem is not that it was an electronic communication, but a failure to serve it on your opposing parties.
Well, they weren't here. They left, but they were here.
By email.
Yeah, they
You
were
should
here.
have copied your email to Mr. Lasper to the opposing side. That's what we're saying.
Okay, I thought that when I hit reply all, that it came from all of us. It came to, I thought it was fair game that it came to me, to all of us, that it would go back to everybody that was on the list. Because I did hit, I replied it, reply all.
Maybe you didn't hit reply all, maybe you just hit reply.
Well, I could look, I'm sure I did.
Okay.
All right, for the record, the reason I'm asking, what I'm asking you is, the reason why. What?
No, there's no proof of service.
Okay.
Okay. Okay, we're on, and the clock.
So I was asking the board to set aside the recommendation of the hearing officer based on the two findings that he made. He said that the standing of the objector was established, and to my point, it was not established because there are 15 Kimberly Williams. I made it. This was the first motion I made. Was that she did not have any standing, and it's like there's a lot more latitude given to her as an objector than if she had signed my petition, or if I had signed the actual statement of candidacy or any of the documents that you require with a different signature. That it would have been challenged, and it would have been overruled. It would have been challenged and then sustained as a challenge by the hearing officer. That this challenge was not substantiated with the proof of who this person was, or whether she was in the district. As I stated, when I came, according to your records, there are 15 Kimberly Williams, none of which is the same as the signature of this Kimberly Williams, as well as in her objection, she has a signature that is still not the same signature. I think that there's a real injustice due to the people of the 26th district to not, there were in fact hundreds of them that did sign the petition in good faith. And I think that it's a real unfortunate to have one person whose signature is not consistent, whose identity has not been verified, to stand against all of those people that said that they wanted to have a choice and they wanted to have me on the ballot for a state representative in the 26th district.
Thank you.
Oh, and one other point, I'm sorry, is that if the state had enacted the automatic voter registration law as it had been adopted at this point, the majority of the objections that were raised, as far as those that said that the people were not registered or were not in the district, would have been rectified. So since and the fact that the state has not enacted that, I think that the board has an opportunity to send a message of their sincere urgency that that law be enacted by reversing the decisions of the other office of the hearing officer, and strike the recommendation and then reinstate the original nominating papers.
Thank you. Okay, that concludes public comment, and now we will return to the consideration of hearing officer reports and proposed final decisions. We have several cases in which the objections were overruled, and the candidates have been found to, the objections have been overruled. The first case is number 11 on the agenda, Michael J. Planfaber, Sr. versus Juan Johnny Elias, 20 EB WC-015. Number 13 on the agenda, William Morton versus Kelly Cassidy, 20 EB WC-023. Number 12 on the agenda, Nicholas Carusi versus Aaron Goldstein, 20 EB WC-016. Is there a motion to adopt the respective hearing officers' reports and recommended decisions, overrule the respective objectors' petitions, and enter final decisions in favor of each of the aforementioned candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motion to adopt the hearing officers' respective reports in the aforementioned cases is granted, and it is therefore ordered that the names of the respective candidates shall be printed on the ballot for the primary election. There's a series of cases in which the objections have been sustained, and they are as follows. Kimberly Williams versus Mark Lovelace, 20 EB RGA-012. John Trineski and Robert W. Reed versus Lauren Young Weber, 20 EB WC-002. That has a related case, 20 EB WC-004. And is there a motion to adopt the respective hearing officers' reports and recommendations, sustain each of the objectors' petitions, and enter a final judgment against each of the respective candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The respective hearing officers' reports and recommendations are adopted in the aforementioned cases. The objectors' petitions in each of these cases are sustained. It is therefore ordered that the names of the respective candidates will not be printed on the ballot for the primary election.
Madam Chair and Commissioners, I have written decisions memorializing these remaining actions taken by the Electoral Board today. I no longer see any parties in the room, but let the record reflect that as soon as this meeting is adjourned, we will make photocopies and deposit those copies for service in the mail to the objectors and the candidates, which will then start the clock for judicial review 5 days under Section 10-10.1 of the Illinois Election Code. And that does dispose of all matters on today's agenda, but the one tabled matter, which is case 20 EB WC-007, where the candidate is Anthony Beal, that case, the board today remanded to the handwriting expert. So I would request that we recess, not adjourn.
Right. Is there a motion to recess at the call of the chair?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
For a recess.
No, I need your help.